item number 40, item number 45 of your lordship's list. But this was made returnable on 13th of November, but has appeared. This was made returnable on the last occasion on 13th of November. It did not.
Hey, Bahadur. One second. আরেকটু ওই দিকে তোমার দিকে
আশীর্বাদ পাইপস
হ্যাঁ বাস আরেকটু এদিকে বাস বাস ঠিক আছে ঠিক আছে yes
but it was made returnable on 13th of November. It did not appear. It has appeared today. But in the meantime, the interim order has expired on 13th of November. I am mentioning upon notice. If your lordship takes it up, takes up the matter in the usual course, then I'll wait. But if your lordship
wait for some time, or else at the time of rising, bring your other side.
But he's here. For the defendant, he's here.
Oh, you are there.
I am for the defendant, my lord.
Ashun.
Milord, we had to file our affidavit in opposition to their GACOM 1. Milord, may kindly extend the time to file our affidavit in opposition.
The interim order has already expired. If your lordship could reimpose that. But this is the last order, man. If I'm
motion adjourned.
Yes, my lord. Adjourned motion. But they have not filed any opposition. They are seeking an extension.
All right. দেখি কাগজ একটু কাগজটা দেখি এই বাহাদুর আসুন. The matter is running in the list against serial number 45. Running in today's list against serial number 45. Poster. Comma, under the heading adjourn motion. আরেকটু আমার দিকে ঘোরা নিচ থেকে আরেকটু বাস 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 না আরেকটু ওদিকে বাস কি বললাম under the heading adjourn motion. Poster. The interim order last extended on September 23, 2025 stands extended on November 13, 2025 when the matter was made returnable by the coordinate bench. However, the matter did not appear on that day. Poster. Paragraph. আচ্ছা একদম মাথার উপর লেখো মিস্টার
Saurajit Dasgupta.
Dasgupta, Learned Counsel appears for the plaintiff. Mr. Rishabh Das, Learned Counsel appears for the defendant. তারপর ওই যা লিখলাম paragraph. In view of the above, for the ends of justice, the interim order last extended. The interim order, though originally passed on.
Lordship will kindly give me 1 minute. Okay.
Originally passed on June 23, 2025. Stands reimposed. Look at it.
Yes, my lord.
Right? Is this the one?
My lord.
Stands reimposed till February 20, 2026.
Yes, ma'am.
2026. Poster. On the prayer of the Learned Counsel for the defendant, time to file affidavit in opposition stands extended till December 16, 2025. Paragraph affidavit in reply, comma, if any, comma, shall be filed by January 15, 2026. Full stop. Paragraph, the matter shall appear under the heading adjourn motion in the monthly list of February 2026.
Grateful.
My lord, may I, my lord, find leave to mention item number 34 of my lord list. I am mentioning upon notice. The interim order is expiring today. So, I'm mentioning upon notice.
Where is the other side?
And I'm mentioning upon notice.
Doesn't matter. Where is the other side? Very well. If I don't call, if I cannot reach there, then mention at the time of rising.
Time of rising. Very well.
If the other side would have been here, I would have extended. No problem.
My lord, may I have a lordship's leave to mention? May I have a lordship's leave to mention, my lord, one order for corrections, my lord. The order was passed by your lordship yesterday, my lord. But two corrections are required, my lord. The amount which your lordship has mentioned, it is incorrect. And my lord,
I have mentioned without submission.
No,
My
your
lord,
lordship, this is that matter where the suit is to
where
be
the suit
withdrawn
is
by the
pending, your
plaintiff.
lordship direct
Instead of 1 crore 25 lakhs, it has gone down as 1 lakh
1,25,000.
Oh, 1 crore. It a card, Baba.
And one place your lordship has recorded that defendant number 1 has never appeared. It is defendant number 2 who has never
It's
appeared.
fifth line from the top, my lord.
Card. Huh? কোনজন এই আমাদের যিনি আছেন on the joint mentioning এটা কত ও না এটা তো টু ও ওটা তাহলে তো লিস্টে অর্ডার হবে না টু বি মেনশন টুমরো
My lord,
তাহলে অর্ডার আপলোড হবে
my lord, grateful.
টু বি মেনশন টুমরো.
But may I, my lord's kind leave to mention an execution application, my lord. It appeared in the list on previous occasion, my lord. There was an order passed and it was made returnable on 6th of November. My lord, may it be listed any day.
It will be appearing in due course.
May I be permitted to mention another, my lord, sued under order 37, my lord. My lord, the defendants have not entered appearance. 10 days have passed, my lord. My lord, subject to lordship's convenience.
Not now because the Lord B suit, let me complete those then.
I was just mentioning because, my lord, because there is no defense, so my lord, summary.
Whatever but the Lord B suit, there are 30, let me cover those then.
Lordship, may I seek your kind indulgence to mention one matter which is fixed on 27th of November at 2 p.m. for the witness action. I'm praying for the inclusion of this matter in the list of.
Sorry, no. Next.
May I have my lord's leave to mention a matter for listing?
Your senior is here.
Your lordship, this is on a general thing. What is happening? This is on a general prayer which we are facing. Matters are getting for pre-litigation mediation which are being filed because of commercial suits. We are filing, many of them have been filed in September. Till now, no orders are being given even for a date for mediation. This is actually defeating the entire purpose. We are not filing straight.
No, you have filed mediation before the mediation officer.
Yes, communication, and this is anybody
before without filing the suit.
Yes, because it's a money claim.
Right. Then
and nothing is happening, your lordship. Months on end, no meeting.
So what is the remedy that I can do?
No, your lordship.
Under the act.
We are pressed because then.
What do I do? Tell me if there is any provision I can experience.
Your lordship, then perhaps if this is actually happening, this leave may be obtained. Leave can be given to file directly now. So the suit, the 12A can be then.
Sir, for the.
I understand your lordship's
act of the mediator. Court cannot bypass the provision of the statute. That provision is not there. That provision is not there.
May I have my lord's leave to mention a matter
These
for listing?
mediators are from the panel of High Court.
Your lordship, these are not no panel. Your lordship, the council sets a date. Councils, they have their own panel. They give a date that you come and do for the mediation. The council itself doesn't give any date for months on end. This entire purpose of filing. So what now? We have to now conjecture somehow to so that 12 days
Come up with the proper proceedings so that I can take judicial notice. But this, I do not know how far I can take under the statute.
No, we can produce the documents which we have filed.
I don't
Correct.
disbelieve. But how? Show me the remedy under the statute so that I can exercise my jurisdiction.
In addition to that, my lord, I should bring to your lordship's notice. The council just do it for the purpose of compliance. Yes, that is no
When it receives the notice only just a day before the.
Sometimes afterwards.
Sometimes after the mediation date is over. Show me the statute.
I understand, but the council must.
Next. Sorry.
May I have my lord's leave to mention a matter for listing? The matter was made returnable on 11th November in this
Under which heading?
under adjourned motion, but it has not
What
been
purpose?
for hearing, my lord.
Sorry, no, it will appear in due course.
Lordship, may I seek your kind indulgence again to mention that matter which was fixed for 3 times, Lordship, for the witness action. That is the.
Sorry, no. Next.
May I be permitted to mention for non-prosecution?
Non-prosecution.
Matters.
To be mentioned next Monday, dear.
Okay.
To be mentioned Monday. Give notice to other side. Next.
May it please your lordship. My lord, this is a suit for recovery of vacant and khas possession of a suit property.
Recovery of?
Vacant and khas possession of the suit property, along with, my lord, recovery of monetary dues in respect of.
Why will you not avail of the mediation?
Well, mediation is done, my lord.
Oh, non-starter.
I have annexed the report. Your lordship will kindly take. First, my lord, kindly take page number 20. My lord, these are the reliefs that I have claimed before.
Show me the non-starter report.
Yes. My lord will kindly take page number 95. Non-starter report dated 14th November 2024. My lord.
Relief in the plaint.
Page number 20, your lordship.
20?
Yes, my lord. Page 20. Prayer B, my lord, is regards to, my lord, the lease rent, a real lease rent that is due and payable. And, my lord, prayer C is in regards to the taxes, my lord.
The non-starter report dated November. No, first of your name, Mr.
My lord, Diptomoy Talukdar, my lord.
Diptomoy
Talukdar.
Moy Talukdar. Diptomoy Talukdar, learned advocate, appears for the plaintiff. Paragraph. The non-starter report dated November 14, 2024, annexure J at page 95 to the petition shows that the plaint shows. So sorry, thank you. Plaint shows that the pre-litigation mediation has failed. Paragraph. Accordingly, the plaint stands admitted subject to scrutiny by the department.
So grateful, your lordship.
My lord, in this matter, I appear for the judgment debtor. My lord, this is the matter where my lord was, or this is that matter where my lord was pleased to direct my client to pay a sum of rupees 15 lakhs by 14th. My lord, that 15 lakhs has been paid. But not within 14th.
Doesn't matter. Paid.
Lordship, so far my instruction is that till yesterday they had received 12 lakhs. I think whatever.
Today morning 3 lakhs have been paid.
Some amount, which I have not yet got the.
May I submit the.
3 lakhs, my lord, has been remitted today. So that confirmation I'm yet to receive, my lord. So, but for the 3 lakhs, for the 12 lakhs, I have received a confirmation.
So 12 lakhs, you admit?
Yes,
and 3 lakhs
has been remitted.
They say they have paid today morning. That's all.
Yes, sir.
But the judgment debtor was directed to be present, but he is on the way because after making the payment from the bank, he is on the way. But may I file the.
So balance remains
15 lakhs.
No, balance, my lord, will be yes, 15 lakhs, 61,000.
20 lakhs. Balance? No.
No.
My lord, it was 30 lakh 61,000.
So balance 15 lakhs.
15 lakh
15 and odd.
15 lakh 61,000.
15 and odd.
Yes, my lord.
Tell me.
My lord, can it be passed over for 10 minutes?
No question of passover. I will not pass any adverse order. I will not observe anything adverse. Within next 15 days, you pay 10 lakhs.
Within next 15 days, it will not be possible, my lord. The property which belong to the judgment debtor.
So very well, very well.
My lord, by 31st of December, we will clear every dues, my lord.
Why?
31st of December.
All right. So next 15 days, 5 lakhs. Thereafter, again, I will make the matter returnable. You will pay more.
But if the money is available, then we will pay the entire amount.
You are free. Ashun. The last order dated November 4, 2025. November 4, 2025 speaks for itself. Acha, মাথার উপর লিখুন Mr. Devashish De, learned advocate for the plaintiff. Mr. Somnath Gangopadhyay, learned advocate for the defendant. এগুলো প্যারাগ্রাফে হবে কিন্তু। তারপর last order dated November 4, 2025 speaks for itself. Paragraph. Pursuant to the direction made by this court in the last order, the defendant judgment debtor has already paid a sum of rupees 12 lakhs, which has been confirmed by the learned counsel for the plaintiff decree holder. Full stop. It is further submitted on behalf of the judgment debtor that today morning a sum of rupees 3 lakhs has been transferred by way of electronic mode.
RTGS.
Electronic mode in favor of the plaintiff decree holder. Post. If the said sum of rupees 3 lakh has been credited, then the total sum of rupees 15 lakh would have been has been paid by the judgment debtor. Paragraph. The judgment debtor shall pay a further sum of rupees 5 lakh on or before. আজকে কত?
18th November.
18. By November 28, 2025, and a further sum of rupees 5 lakh on or before December 10, 2025. Paragraph. The matter shall paragraph. Learned counsel for the defendant on instruction from his client, judgment debtor, submits that the judgment debtor is making endeavor to pay the entire decretal amount by December 31, 2025. In view of the above, the matter shall appear under the heading to be mentioned once again on last second payment ta kobe bolechi
10th of December.
Once again on December 11, 2025. It will appear as to be mentioned.
Grateful. But the absence till now of the judgment debtor may be dispensed with, my lord.
No, the judgment debtor shall also be present on the next day.
For the time being, my lord. That's all.
No question of dispensation. On the next day, he will be present.
On that date, he will remain present, my lord.
Naturally, he will come and sit here.
Grateful, my lord.
He will the judgment debtor. Judgment debtor is a natural person, individual.
Yes. No, judgment debtor is the company. His director is
the director of the judgment debtor who regularly visits, who regularly is present before this court, shall also be present on the next day personally.
Grateful, madam.
Serial numbers 3 and 4, my lord, can be taken up together. Common order may be passed, my lord. In the last,
Why to be mentioned?
my lord, in the last order, my lord, your lordships had extended the interim order, my lord. It was to be extended up till February 26, my lord. It has erroneously gone down as February 25.
The matter appears under the heading to be mentioned for correction of an apparent typographical error on the face of the order dated November 13, 2025. ওই দুটো মাটার একসঙ্গেই অর্ডার হবে, একটা অর্ডার, ঠিক আছে? 3 আর 4, তাই তো?
Yes, my lord.
একসঙ্গে অর্ডার হবে। এই 3, 4 একসঙ্গে দেখিয়ে দাও প্রদ্যোৎ। হ্যাঁ, 3, 4। The interim order already extended and the date should be corrected as February 16, 2026, bold. February 16, 2026 in place of 2025. ঠিক আছে? Paragraph, the said correction shall be incorporated in the order dated and read into. Incorporated and read into the order dated November 13, 2025.
Grateful, my lord.
বলে দিলাম তো, shall be কি বলেছি পড়ে দাও, read into.
Order item number 5.
My lord,
No accommodation, I will proceed. Proceed.
they were to proceed.
My lord, so Mr. Thakur had
Proceed.
Mr. Thakur had
এই কাগজ। এগুলো গেঁথে রাখো না কেন? একটা ফাইলটাই করে গেঁথে রাখা সব, মানে যেটা না বলবো সেটা হবে না। এত বছর ধরে করলে 2 নম্বরে আমার সঙ্গে কাজ। এটা একটু সরিয়ে দিতে পারো না? সমস্ত জাজমেন্ট যে যখনই দেবে না প্রদ্যোৎ, ওপরে লিখবে পিটিশনার,
actually supports.
1 second.
I'm sorry.
অর্ডারের কপিটা কোথায় কালকে? কোনো অর্ডারের ফাইল নেই? এই পাখাটা যদি চালাতে বলো তো, ওই পাখাটাও চালাতে বলো। ওই পাখাটা দেখি। আরে অর্ডারের ফাইলটা, কালকের অর্ডারটা কোথায়?
ऑफिस में जो टेक्स्ट बुक
সার্ভারে তো আছে।
तो आया तो लेके नहीं आया ऑफिस का टेक्स्ट बुक। अब छोड़ो, अब इतना दिन मतलब मार्केट खत्म हो जाएगा।
সার্ভার হয়েছে তো? হ্যাঁ, কালই হলো। Yes.
The
Yes, sir.
Supreme Court judgment, which my learned friend cited, Shalimar Rope Works.
Correct.
I've shown your lordship, my lord, hopefully that this judgment in fact supports my case. We fall in the second part of 29(2), which requires only addressing it to the registered office, nothing more.
Show me.
Lordship will kindly have, my lord, 1983 SCC 595.
That's right. Which paragraph?
Paragraph 7, please, my lord.
Read.
The meaning of clause B, which we are concerned with, the meaning of clause B has got to be understood in the background of the provisions of the code in order 5, which is meant for issue and service of summons on natural persons. Sending a summons by post to the registered office of the company, unless the contrary is shown, will be presumed to be service on the company itself.
That's what I said.
Yes.
Just addressed and posted, reach sufficient.
Sufficient. Now, but the first part of clause B has got to be understood. So we are not concerned with the first part. It was sent by registered post to the office. We are in the second part. As far as the first part is concerned, he admits the first part also, but he says it was on a subsequent date. So obviously the prior date when he received by registered post will prevail.
The first service.
First service will prevail. 7 and 8, my lord, they say the same thing. So this judgment in fact supports my case. The facts in this case before the Supreme Court were different. It was by hand service on a person who was unauthorized. This is not our case here. The hand service according to him is authorized. He insists that the postal service should also be on the managing director.
This is your submission.
This is my submission.
Next.
Now the next judgment he cited, one he has handed over yesterday.
আমার দিয়েছে?
একটা দিয়েছে, but 70 SV Enterprises Welkin Auto.
ওই আমার দেয়নি তো?
রিলাই করবে না? না করবে, করবে, এটা করবে রিলাই। আমাদের তো দিল কালকে।
There is one more judgment, my lord, we had found out yesterday, so I'm handing it over to Mr.
এইটা এসভি করবে না করবে না? করবে। আরেকটাও আছে। আচ্ছা, মানে they've not placed this, but they gave me a copy yesterday, so just to save time, may I distinguish it right away? Kindly have 20
copy. হ্যাঁ, ডিফেন্ডেন্ট লেখো, ডিফেন্ডেন্ট আজকের তারিখে
हर जजमेंट का दाओ। तुम्हारा क्या जजमेंट है दिखाने का?
এটা আমরা রিলাই করব।
अब ये तो हो गया प्रूफ ना।
My lord, I'm told that it has all.
এই কম্পিউটার ছেলেটি কোথায়? বাবা এই একদম উঠে এসে এখানে এসে এইখানটা না তলা থেকে বেস থেকে একটু আমার দিকে ঘোরাও, ডিস্টরশন হচ্ছে। তুমি এদিকে এসো না, এখান থেকে ওঠো না।
এটা দিয়ে দিন।
ওটা জায়গা নেই। হ্যাঁ, জাস্ট বেস থেকে একটু ঘোরাও, তলার থেকে হাত দাও। হ্যাঁ, আর একটু। হ্যাঁ হ্যাঁ, বাস চলো, ঠিক আছে। ইয়েস, আবার এইটাকে আলাদা করলে কেন?
My lord,
এটা রেখে দাও, একটাতেই হবে, একটাই করো তাতেই হবে। না, আটকে দাও, একটাই করো তাতেই হবে।
আরেকটা, my lord, I'm being led by Mr. Sengupta, your lordship. May he take over?
আরে let him distinguish, then he will place. How does it matter?
Kindly come to your lordship has SV Enterprises, my lord, the judgment of our court.
Yes. Yes.
This was an application for recalling an ex parte decree, which your lordship will find in the first paragraph. This is an application at the instance of the defendant under Order 9, Rule 30 for responding ex parte decree. Now kindly see paragraph 3, please, my lord. In the cause title of the plaint filed in the suit, the petitioner as the defendant was described as an existing company under the Companies Act 1956, having its registered office at B40 Phase 3 Industrial Area, Mohali. The petitioner has asserted that although it had its registered office at the address mentioned in the cause title in the plain, and at present...
So in this matter, Mr. Sengupta appeared.
Yes.
Yes.
Mr. Sengupta appeared, yes.
Yes.
I think he was successful.
He was successful or
Yes,
defeated?
seems he was successful. Decree was set aside. That is why, my lord, he's relied on his experience now. But unfortunately, the facts don't support him again. Kindly come to paragraph 3. Where was the summons actually served is required to be seen, my lord. Kindly see paragraph 3 once, please. Petitioner address was given. Then kindly see, it is further alleged. Paragraph 3, please, my lord, 5-6 lines from the top. It is further alleged. It is further alleged that though in the cause title of the plaint filed in the suit, it mentioned that the defendant number 1, petitioner, was also carrying on business at 3/1 Mango Lane, Kolkata, care of Sethi Construction Company. In fact, the petitioner, kindly see, had no office within the jurisdiction of this court. The description of the petitioner in the cause title of the plaint filed in the suit, that it is carrying on business at 3/1 Mango Lane, Calcutta, so-and-so, is fraudulent, misconceived and false. This was the case. That this is not my address, I don't have anything. And now, my lord, kindly see the finding. Kindly come to paragraph 8, my lord. Paragraph 9. I'm sorry, paragraph 10.
Yes.
The first ground urged by the petitioner for recalling of the ex parte decree dated so-and-so is that the writ of summons of the suit was not served upon it. Paragraph 10, your lordship sees, this is a total case of non-service of summons. The petitioner has further asserted that it never had any administrative office at 3/1 Mango Lane, nor did it carry on any business from the said address.
It's got nothing to do.
Nothing. I don't know why he cited this. Kindly see the next. Just turn over, my lord, to paragraph 11, please, my lord.
Correct.
Kindly come to paragraph, however, about 5 lines from the top. This was a case of non-service of writ of summons. Kindly see 5 lines from the top, please, my lord. However.
Wait. Yes.
However, from a bare reading of the certificate issued by the Deputy Sheriff of Calcutta, it is evident that the writ of summons of the suit was sent to the petitioner at 3/1 Mango Lane through the second officer, but the same could not be served upon the petitioner due to its non-existence at the said address.
That's a different.
Thus, the respondent has, kindly see, respondent has failed to substantiate service of the writ of summons of the petitioner at its registered office at Mohali in the state of Punjab. This my writ of summons has been served at his register.
Admits.
Yes, he admits now. Fortunately, now, my lord, he has just handed over one more decision. Kindly have Praveen Chandra, Murli Agro Product. He's given me, my lord.
You are favored.
I am favored, my lord. He's making life more and more difficult for me. Kindly see. He has just handed over, my lord. Kindly see paragraph 2. This was also an application for setting at a ex parte decree. Kindly see about 6 lines from the top. He contended. My lord has that?
Paragraph?
Paragraph 2, about 6-7 lines from the top. After that, another judgment of the court is noticed in italics. He contended, your lordship has?
Yes.
He contended that the suit summons was served on Ravi Kumar, who is an employee of the defendant, and the service was valid in view of the provisions of subclause B of Rule 2 of Order 39 of 29 of the Code, which contemplates that where so. So, Mala, this was again a case of service by hand on a person not named in 29(1). Then kindly see 3. Learned counsel for the respondent contended the application for delay was not barred by limitation, etc. He supports the impugned order passed by the learned so-and-so and contended. Kindly say about 5 lines that service on the defendant, which is a corporation, was not valid as it was accepted by Ravi Kumar, a clerk, who did not inform the director or the managing director regarding the receipt of summons. He contended that mere, now kindly see, handing over of the summons to an employee. So handing over, your lordship kind sees about 6 lines, third paragraph, 6 line, right hand side, he contended that.
Yes.
He contended, kindly see the case, he contended that handing over of the summons to an employee of the corporation who was not authorized to receive the summons would not make the service valid within the meaning of 29(2)(b), therefore no inference, and so and so. And then the Shalimar rope works judgment is considered. This is the first part of 29(2)(b). Part 1, handing over to an employee is not correct. But this does not deal with a case of service by post. And that is why Shalimar has been followed.
All right, next.
Now, so these judgments perhaps don't come to the assistance of the respondent. The facts are entirely different. My lord, yesterday your lordship had a query that why this dual mode of service. That is because, my lord, our rules say Order 5, Rule 19A, which prior to amend, with now Civil Procedure Code, because our rules have stopped at Order 5, Rule 19A, we have not amended our rules. Order 5, Rule 19A, prior to its deletion, provided for both modes of service. In addition to bailiff, service by post. That was there. Now, Order 5, Rule 19A has been deleted from the statute, and Order 5, Rule 3 has been amended to provide by post service by post. So, the effect is the same. That is why the two modes of service, whichever is received first, there's one judgment of the coordinate bench. Kindly, Fox and
What does it say?
It's prior service, my lord, only for that. Prior, the service which is prior in point of time.
That's
not
required.
Great.
It's an elementary.
Yes, great. So, since so many have been cited, well, my client will cite it.
Yes, Your Lordship. So now your lordship has understood one thing, which date should be taken. Now, if your lordship forget about this matter of the law, there is a difference between a natural person and a company. Natural person, we know, your lordship, who is the addressee. In case of a company, your lordship, the name of company is there, but neither the bailiff nor your lordship, the postal department knows that who is the person authorized to receive it on behalf of the company. Now, if your lordship kindly sees once Order 29, because it's Order 29, your lordship, has to be read, your lordship, in a holistic manner in entirety. Yes, sir. Lordship kindly sees, subject to any statutory provisions regulating service of process where the suit is against a corporation, the summons may be served. To whom? On the secretary or any director or principal officer of the corporation. Now, when Mr. Thakkar has placed my judgment of the Supreme Court, when it said that it has to be read with Order 5, Rule 17. Why? There are steps. Now, if suppose the secretary, your lordship, has refused to take it, then the question arises by leaving it or sending it. So therefore, there has to be first refusal. That's my, your lordship, understanding or my reading of the. Otherwise, what will happen? If your lordship kindly sees the service report and the report filed by the sheriff, nowhere it is written who has received it. When the acknowledgement due card comes, we can see who is the person signed it and where is the seal. A person, your lordship knows, your lordship, the person who is holding the seal has the authority to receive any communication on behalf of the company. But from the track report, it can't be shown. And the service report also says that the acknowledgement due card has not come back. So therefore, your lordship, it cannot be presumed. And it's
now the sheriff's report says that it was delivered.
It was delivered.
Registered post was delivered
Registered
at the registered address.
Exactly. But registered post was delivered to whom it is not mentioned. Because the person, your lordship, why I'm saying so?
Sir, tell me. When a notice is addressed,
yes, your lordship,
in the name of the company at its registered office, is this the duty of the peon that he must search out who is the director or who is the secretary, and then he will give it to him.
No.
And if I say that give it to me, he will say, no, I will not give it to you. Show me first, prove you are a secretary or you are a director.
Yes.
The moment it is registered post, if it is delivered at the correct address, matter ends. That's the presumption of law.
But subject to rebuttal. Subject to rebuttal.
What rebuttal?
The rebuttal is when I am coming before the court and saying, Lordship has to differentiate.
Your
two things.
rebuttal should be that it has never been delivered at the registered office.
Lordship, that's exactly I've said so.
But
because
that is not your case. Your case, it was registered at my Delhi registered office, but not to the principal officer or whoever, secretary or director.
In the reply, Your Lordship, I've cleared it. I have disputed both. I have disputed, Your Lordship, that the letter has not, or the writ of summons along with the copy of the plaint has not reached at the registered office. First.
Show me your
Yes,
reply.
Lordship, may I just place it?
Which
Page 3
paragraph?
onwards.
Which
Your Lordship,
paragraph?
paragraph PF.
Yes.
The second part of the, or rather, Your Lordship, may I read it from E, Your Lordship, then it will be a proper sequence. The annexure of the said affidavit as disclosed by the plaintiff shows the seal bailiff from the Sheriff's Department of this Honorable Court indicates that the same has been served with the said writ of summons by hand on 22nd November 2024. The defendant in the instant application filed before this Honorable Court in the application under Order 8 Rule 1 of the Code of Civil Procedure has also made some contention.
Made
the same contention.
You are reading from paragraph F.
From E, Your Lordship. I just placed E. E, Your Lordship, we admitted. Your Lordship, on 22nd, we received it. Now, Your Lordship. The second part of the said report of the Office of the Sheriff, dated 10th February 2025, as annexed to the affidavit of the plaintiff, states about the postal service through speed post with acknowledgement due card. But the said report does not include any document which would show that the concerned department of the sheriff has served the writ of summons by post and the same was duly received by the defendant on 14th. However,
this report comes now.
Now, Lordship, kindly come further. However, further, the second part of the said report does not indicate whether the concerned department of the sheriff of this Honorable Court received any postal acknowledgement receipt or undelivered packet. In any event, the defendant or any of his directors or principal officer and or any authorized persons have not been served with the copy of the writ of summons along with the plaint and other documents on 14 November 2024.
Admittedly. But the moment writ of summons has been served by registered post at your registered address and the postal report comes, it is served, matter ends. It's not required to serve personally on the director.
Lordship, with deepest respect to Your Lordship, there has to be, because that's the only reason why this acknowledgement card concept was there. So that Your Lordship can understand who is the person who has received it. Lordship, with deepest respect, this is not a natural person. This is a company. And somebody who is holding a seal has the authority to do it. I understand. But Your Lordship kindly sees the track report. It shows only addressee.
So, the order 29 B,
yes,
2B does not provide for that. It simply says registered post at registered office. A provides for principal officer. B does not provide for that.
But it has to be read, Your Lordship, with A then B. Lordship kindly sees, Your Lordship, the Supreme Court's judgment once. May I place it? And then Your Lordship kindly sees the Honorable Bombay High Court's view on Order 29 Rule 2 B. And Mr. Thakkar is saying, no, it's B, first part and second part. Then in that case, Your Lordship, there would be, with deepest respect, there would be a very absurdity in the commercial suit. Otherwise, what will happen? The postal articles will go to a company, and if the company's person or not, because I don't know, Lordship, whether he has given me that particular article to my neighbor, to a different office, to the same office, I do not know, because there is no acknowledgement due card where the name is mentioned. Because the sheriffs, I can, Your Lordship, cross-examine the sheriff or Your Lordship, the seconding officer. Lordship, the postal department. The reason, Your Lordship, is very simple. That is the intention of the legislature. When there is a company, first you have to go and find it out. If that particular principal director or the principal secretary is avoiding it, then order 5 rule 17 comes into the picture.
So for every company, 2 times they will visit.
Yes. That's your lordship. That's exactly, he has done it. Exactly, your lordship, the sheriff has done it. He sent the postal article first.
By registered post.
By registered post. If your lordship, with deepest respect, that is the only criteria and the sole criteria, what was the use of going the bailiff? And if the bailiff has gone and given it to your lordship, the principal officer, then why that particular date should not be taken when there is a doubt? When there is a doubt, because today the sheriff has not given a report that such and such person holding the seal received it, and he is the person who is authorized to receive the summons, I understand. Then the question arises whether that particular person is authorized or not. But you kindly appreciate, I have not come before this honorable court after the decree. I have come before this honorable court at the initial stage. And I am saying, your lordship, the first date should be taken up. Now, your lordship has understood, your lordship, that in a normal suit, I have a remedy. But today, I would be remediless. I don't have any defense. And if Mr. Thakur's submission is accepted, then in that case, anywhere, your lordship, the company will receive it. Nobody, your lordship, the court will not see who has received it, neighbor, whether your lordship, the security guard at the gate, and your lordship, by 120 days, your lordship will start. Because that's, your lordship, the time machine will start. Now, your lordship kindly sees, your lordship, the Supreme Court's judgment.
Shalimar.
Yes.
Yes.
Lordship, kindly take, Mr. Thakur has shown, your lordship, paragraph 6 onwards. First portion of the paragraph 6, I am not reading because that's the provision.
Yes.
Para 6, first portion, I am not reading. Lordship, it starts from rule 2.
Correct.
Now, rule 2 is not an exhaustive provision providing for all modes of service on the company in the sense as to what is meant by service of summons on the secretary, director, or a principal officer. In Jute versus Gunny Brokers Limited versus Union of India, it was held that the word principal officer in clause A of rule 2 would include managing agent, and it can under this rule be on a juristic person. Accordingly, the service of the managing agent who are corporation is valid under clause A. Clause A is completed. Now, the meaning of clause B has got to be understood in the background of the provision of the code in order 5, which is meant for issue and service of the summons on natural persons. Now, here, your lordship, just may I add it here, your lordship, kindly appreciate, here, your lordship, the bailiff has not gone first. Is the registered post has gone first, and then the bailiff has gone. If the bailiff has gone first and the person has refused it, he has pasted that on the wall, and then the registered post or the speed post has gone there and it is received. Matter ends. Matter ends. But here, your lordship, it's actually a reverse of that. Now, your lordship, kindly sees paragraph 7. The meaning of clause B has got to be understood in the background of the provisions of the code in order 5, which is meant for issue and service of the summons on natural persons. Sending a summon by post to the registered office of the company, unless contrary is shown.
Yes.
Unless contrary is shown.
Yes, that's the rebuttal.
Will be presumed to the service of the company itself. Here, your lordship, I am saying, your lordship.
Sending.
Yes.
So not required even to show that, yes, it is received.
Yes.
Mere sending will sufficient.
Lordship.
But here the track report is there that it has been delivered to the registered office.
It has been delivered to the addressee.
That no, at the registered office.
Yes, your lordship, I presume that at the registered office. But that particular track report or the report of the sheriff is not showing that who has received it.
Absolutely, I agree. That's
Yes.
what I agree.
So there is.
But whether that is to be adjudicated, whether it is an essential to show that even if it is by registered post and it is shown that yes, it has reached at the addressee, then who has received on behalf of the addressee? That part is to be adjudicated, nothing more than that.
I am grateful. Now,
According to you, it's the principal officer, and principal officer. Who is defined?
It's a director, secretary, or principal
I mean,
officer.
who is
Yes.
defined? Order 29.
Or any managing agent.
Who is defined?
Yes. Now, Your Lordship kindly sees. Sending a summons by post to the registered office of the company, unless the contrary is shown, will be presumed to be service on the company itself. But the first part of clause B has got to be understood with reference to the other provisions of the code. In Rule 17 of Order 5, it is provided where the defendant or his agent or such person as aforesaid refuses to sign the acknowledgement, or where the serving officer or the serving officer, after there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom the service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous place, part of the house in which the defendant ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it is issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances in which he did so, and the name and address of the person, if any, by whom the house was identified and whose presence the copy was affixed. Now, Your Lordship can understand, Your Lordship, if sometime our doors are locked, the peon comes, and Your Lordship, with deepest respect, an intimation is given. And Your Lordship, in the postal record, it is mentioned intimation served, where Your Lordship, somebody has refused to actually take it. So therefore, the Honorable Supreme Court is saying that once Your Lordship, the main persons, Your Lordship, who has the authority, refuses to do that, then Order 5 Rule 17 comes into the play. Now, once Order 5 Rule 17 comes into the picture, then he leave it or paste it. And that's the last one is by sending a registered post. Here, A has not been qualified. B, first part not qualified. C, though as per the report of the sheriff, third part has been fulfilled, but not mentioned who is the person. So I am, Your Lordship, covered by A, first portion of B, third portion of, or rather second portion of B, but there is a doubt. Whether in this circumstances, where Your Lordship, I would be remediless, my defense will go, whether Your Lordship will take that particular presumption as Your Lordship, a service of that particular writ of summons with the plaint will be accepted or not. I leave it to Your Lordship, and Your Lordship kindly sees the Bombay High Court judgment, which is clarified, Shalimar. Your Lordship, kindly take Bombay High Court once.
Give me.
Tell me.
ওইটা জাজমেন্টের ফাইলে ঢুকিয়েছো এখন? হ্যাঁ, আজ ফাইলে আমার একবার দেখিয়ে দিন। হ্যাঁ, এটা তো দিয়েছে।
That's the same Bombay.
দিয়ে দাও, ফেরত দিয়ে দাও। আমার দাও, একবার দেখি না।
You should kindly take paragraph 2.
কেন রেখে দাও। আচ্ছা, এখানে দাও। Yes.
Paragraph 2, Your Lordship, Mr. Chabra, learned advocate for the applicant, contended that the application filed by the defendant for setting aside of an ex parte decree has been brought beyond the period of limitation, as the decree was passed on such and such date, where the application was filed on such and such date. He contended that the application should not have been registered. Application should not have been registered. In support of this submission, he relied on the judgment of Vijay Prabhakar Shalunke. He contended that the suit summon was served on Ravi Kumar. Here, Your Lordship, no person is there.
Absolutely, this I agree. Here, the second modality was not exercised.
Why?
Registered post.
Deepest respect, why?
Yes. It was served on a person who was not authorized within the meaning of the act.
Correct. So therefore, the bailiff gone first.
All right.
The bailiff gone first, Your Lordship. May I just read it, Your Lordship, for Your Lordship's convenience? Served on Ravi Kumar, who is employee of the defendant, and the service was valid in view of the provision subclause B of Rule 2 of Order 29 of the Code of Civil Procedure, which contemplates that where a suit is against a corporation, the summons may be served by leaving it or sending it by post addressed to the corporation at the registered office, or if there is no registered office where the corporation carried on business. He contended that the defendant did not plead in their application for condonation that Ravi Kumar is not authorized to receive the summons.
Yes, and we have read it.
Yes.
Yes.
So therefore, and that
contention is that appropriate person, unless is delivered with, it is not a service or not an acceptance of service on behalf of the company.
Lordship.
I understand.
And registered post aspect, your Lordship, has also been considered by Bombay High Court. Now, your Lordship, kindly sees the last paragraph, paragraph 6.
Yes.
The apex court in the case of Shalimar cited supra held that the meaning of clause B of Order 29, Rule 2 of the Code of Civil Procedure has to be understood with reference to Order 5, Rule 17 of the Code of Civil Procedure, and mere handing over the summons to an employee not authorized to receive the summon does not amount to a valid service of the summon of the company.
Absolutely, I'm agreed. I agree with you because there was no registered post. So mere service, mere hand delivery has to be on the officer concerned.
Lordship.
I agree with that.
Yes.
No doubt about it.
And my second limb of submission, that even if it is served on the company, but it is not mentioned who is the person who has received it. The postal department, your Lordship, without your Lordship, the examination or process, if your Lordship is accepting the plea, without their examination, it cannot be presumed, and your Lordship, valuable right would be curtailed. These are my submissions.
That's the harsh
commercial code
provision under the Order 8 in view of the Commercial Act.
That's why, your Lordship, on Order 5, Order 5 also, that particular proviso, your Lordship, is given. So that, your Lordship, the courts, your Lordship, will be very confident that your Lordship, correct, because you have to be also more cautious, and department, and yet the department has specifically mentioned in the first column the principal officer has been received. Why?
All right. Thank you.
I'm grateful.
Grateful.
Any further? Mr. Sengupta, any further?
He is insisting, your Lordship, I don't know.
Paragraph C of his
Paragraph C of his application.
written
objection. Affidavit of, as the writ of summon was received by the defendant on 14th, the stipulated time of 30 days to file the written statement expired on 13th, and the extendable time of 120 days of revision expired. So, this is a statement.
This is what I'm saying. This is correct. 14th is correct.
That's his case.
Nothing
That's
further.
his only case.
Nothing further?
Nothing.
Happy? Both of you?
Yes.
Chalo. Asho. Lekho. After submission having been concluded by Mr. K. Thakkar, Learned Senior Advocate Krishna Das Thakkar, Learned Senior Advocate appearing for the plaintiff, Mr. Subhashish Sengupta, Learned Advocate appearing for the defendant, has also concluded his submissions in reply. Full stop. Paragraph. Parties have concluded their submissions. Paragraph. Judgment stands reserved.
Grateful. Deeply
grateful.
এগুলো তুলে রাখো এটা করে না আমার সই হয়ে গেলে আজকে পাঠিয়ে দেবে লিখে দেবে পাঠিয়ে দেবে হ্যাঁ আজকে লিখে দেবো নেক্সট
This is my I appear for the plaintiff at the outset, Milord. I'm being led by Mr. Dhruvo Ghosh. He is not available today for his personal reason, Milord. Kindly, Milord, let the matter. Milord, I'm praying, Milord, for adjournment, Milord, for today.
Pay cost, secure the amount, get the adjournment.
But there's no amount, Milord. This is my suit. I appear for the plaintiff. He has filed an application
Very well.
seeking dismissal of the plaint.
No question, sir. You are competent enough. You should proceed.
Yesterday afternoon, the reply was served upon us. Affidavit in reply. It was not served within time.
Whatever
It is, I have to sit with the senior advocate that is appearing in the matter.
You are for?
I am for the plaintiff. I am the advocate on record. I am the advocate on record.
We are within time.
No, it was served yesterday.
We are
The
within
affidavit in
time.
reply.
Kindly look into your
Kindly
last
see
order.
last order.
আমি বলে দেবো ওটা আমরা 17 তারিখ অব্দি আমাদের তারিখ ছিল ওরা জানে না অর্ডার না দেখে কথা বলছে কালকে তো 17 তারিখই ছিল মামলা করতে পারবে না বলে দিক মামলা করতে পারবে
The order was passed in their presence. Ajay ko author.
18th. 18th.
Yes, 17th the day.
Yesterday they have served, but
That was the day when they will
senior
serve.
advocate was not. Yesterday it was served upon us.
So when did you expect?
On Friday itself, it could have been served, or
They
Saturday.
could have made submission on the last.
See, because I have to sit with the senior
Passed
advocate.
over for the day.
Great. Lord, may I
Pardon, may I file my affidavit in reply? No, keep it with you. Passed over for the day.
Grateful.
Deep blue.
New motion item number 7.
Yes.
I'm for the defendant number 1. I'm for the defendant number 1.
Whose application?
My application.
Yes.
My lord, the suit was filed
What
on
is the application for?
application for refund of GA number 3, GA3.
Application for?
Refund of money kept with the register.
Payment of money.
Refund of money. Refund of money.
Refund of money. Why?
I'm saying.
Affidavit complete.
No, my lord.
What is
Till
the nature of the application? देखिए. Deposited by you. Why refund? What was the nature of the plaint?
Nature of the plaint was 2 issues, my lord. Number 1, it is
Show me
bank
the prayer
permission-
from the plaint.
Yes, ma'am.
Show me the prayer from the plaint. देखिए कागज दो.
There are 2 issues,
Huh?
my lord.
चेचिए. प्लेंट नहीं. एप्लीकेशन है प्रेयर देखिए प्लेंट आ चुकी ना. एप्लीकेशन का दो. एप्लीकेशन नहीं था. Give me a copy of your plaint.
It's plaint or my application, my lord. It is my application.
ম্যাডাম ওই ওটা কি ছেপেছে একটা আপনাদের কাউকে হ্যাঁ হ্যাঁ বলুন দেখি এরকম করলে আমি কি করে সামলাই আমায় যদি টাকাটা দিতে বলতো আমি কি করতাম আচ্ছা আরেকটা আমি বলেছি কার আমি জানি না 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 যেটা ওই আমি চেম্বারে এনেছি কারেকশন করে দেবো বলেছি একটা আপনাকে বলেছে যে খাতা পেন নিয়ে আসতে হ্যাঁ 12টা 20 আমি নামবো খাতা পেন নিয়ে আসবেন এইটুকু করে দিয়ে দেবো চলুন ইয়েস লেট মি সি
My lord, in brief, I am telling, my lord. 2 issues of the bank premises matter, my lord.
Where is your plaint?
It's not my plaint.
It is not. It is the application. Application I have. দেখুন কে দিল ওটা ফেরত দিয়ে দাও ফেরত দাও Yes.
There are 2 issues, my lord, which is the bank premises matter.
Wait. Suit for eviction.
Regarding the area rent and also the municipal taxes and commercial charges dues.
Show me which order by which order you have paid. 1 crore 20.
Yes, ma'am. In my application, my lord.
Which order you have?
Yes, ma'am. I'm showing. Order dated 14th November 2018.
Which
Annexure E.
Page
32 in my application. Ma'am. And minus page 34, I lost also.
Page 34 and 35 also, my lord.
Yes, so order has been stayed.
Order has been stayed and
Corporation order.
yes, my lord.
It is
State
stayed.
and my lord, bank prefer and also challenging that order of the KMC, my lord, prefer and read before this court, my lord. And on that cases, my lord, they have not filed any objection, and on that day they submitted. They submitted.
Considering the issue involved in this petition, considering the issue involved in this petition, and considering the prayers made therein, comma, this court finds there is no scope of any interim order. Full stop. Paragraph, affidavits are required to be exchanged. Paragraph. The respondent's plaintiff shall file affidavit in opposition. On or before December 16, 2025. Paragraph, affidavit in reply, if any, thereto shall be filed by on or before January 14, 2025, 2026. 2026. Paragraph. The matter shall appear under the heading adjourn motion in the monthly list of February 2026. Thank you. এটা ফেরত দিয়ে দাও। কি অ্যাপিয়ার করেছে দিয়ে দিয়েছে?
Next.
Item number 8.
But in this
Global Services.
in this matter, I appear on behalf of the plaintiff, my lord. But I had taken out a application for summary judgment on order 13A summary judgment.
Where is the defendant? Have you served?
My lord, I have served there 2 times. My lord, the last order was this, my lord. Kindly, my lord.
Affidavit direction made.
My lord, affidavit of service with respect to the.
Not service.
But I have served them up on through email. Because the door is locked, they are not receiving 2 times someone has been issued. GA4, my lord.
You have served on the email ID?
My lord. My lord, this is the affidavit of service.
Huh? Oh, no paper লেখা আছে, পেপার এসছে? পেপার আসেনি? তো সেটা বলো না প্রথমে, পেপার আসেনি। বলে দিলেই তো হয়ে যায়। Let the papers come. Next.
Paper application. Item number 9.
I'm for the decree holder, my lord.
My lord, I am for the judgment debtor as well as 3 directors of the company who are not the judgment debtor, also has not been arrayed in the suit. They are not judgment debtor, not a party. My lord, there was a order by Honorable Justice Parthosarathy Sen sometime on 21st February 2025. I have filed 3 general applications by 3 directors who are not the party for partial recalling of the order.
Where is the decree?
Yes, ma'am. Lord, decree is my execution application, my lord.
This is an application filed by whom?
My lord, G application filed by my learned friend.
GA2.
GA1, 2 and 3.
My lord, may I submit, my lord?
My lord, this is my
What is the order dated 21st of February?
21st of February, my lord.
My lord, page 6 of the application, my lord.
Nine.
Show me the decree. Show me the. You're carrying a copy of the decree.
Yes, my lord. It is.
Show me.
My lord, I have annexed in my execution application, my lord.
Execution আছে এখানে?
Execution number 487 of 2024.
Master summons দাও, তো tabular statement থাকবে।
At page 17, my lord.
Decree for what? Money?
Money. Recovery of money. May I submit in the short, my lord? I have sold and supplied the defendant Senco Jewelers gold materials, my lord. Thereafter, they have
goods sold and delivered. Price are not paid.
Part
suit filed.
Check dishonored, my lord. Admitted claim.
Suit filed. Decree for 25 lakh.
Yes, my lord.
25 lakh.
Degree for 25.
20 lakh.
20 lakh plus
50,000.
Plus interest. Plus interest.
Against the company.
Against the company.
Naturally.
And
thereafter,
I have
now
filed
the directors are directed to file their affidavit of asset. What about the company?
Company has filed its affidavit of assets, my lord, but the directors have not filed. Though there was
filed its affidavit of assets.
Company has
Is
filed
it part of the record?
Yes, my lord, it is part of the record. Company has filed the affidavit of assets.
Show me from the application or whatever.
They have filed separately. Affidavit of assets, they have filed separately.
I have
Separately?
Separately.
Affidavit of asset.
Here,
no.
My lord, here I am for both. Number one, for the judgment debtor. Number two, who are not the judgment debtor but affected by the order of Honorable Justice.
Oh, nothing. That will be seen later. Don't worry. First, let me see the affidavit of asset. এখানে আছে? দেখো মাস্টার সামন, এটা তো হচ্ছে GA2। দাঁড়াও না, এটা তো ইসি। Running business.
Running business, my lord, but through loss, my lord.
So I'm appointing receiver on the business. He will take possession.
My lord, actually, my lord, what happens, my lord, I am telling you, lord.
Sir, two way to look at it. It's a commercial court. You have suffered the decree. Either you pay off or lock, stock and barrel you should go.
My lord, here I am. My point is not there, my lord. My point is not there, my lord. Against the decree, my lord, I have filed one appeal. It is no doubt that no stay has. I have failed to bring any stay order.
I will proceed with the execution.
My lord, before proceeding with the execution, my lord, I have 3 applications for the directors, my lord, who are.
I will not touch the director for the time being. I will go on proceeding against the debtor.
My lord, so far against the judgment debtor, the Senco Jewelers, which is that it has already been started, has already started to pay in respect of some other defaults, my lord.
Next week, pay 10 lakhs.
My lord, it is impossible, my lord. I am telling you.
I am appointing receiver of the business.
My lord,
Can you see the last order, my lord? Last order passed by Justice Rao, my lord.
That is true. That last order.
Court was not satisfied with their affidavit of
judgment.
So let the receiver go and take possession, put padlock on your shop.
Today, my lord,
they are running through loss, my lord. So, my lord,
Let them suffer.
I have a talk with the judgment debtor also, the directors also, my lord. They are, let me submit, my lord. They will consider for payment, my lord, no doubt. I am particularly using the word consider, my lord, because they will consider.
Sir, next week will you bring 10 lakhs?
My lord, it will be impossible.
Very well. Let a receiver be there.
It will be impossible, my
Receiver
lord.
shall take.
Your lordship may please defer it up to January, my lord.
No.
First payment will be made by January.
First, you show your bona fide by 10 lakhs.
My lord, it is impossible. They cannot do it. They cannot do it, my lord. My lord, I am telling.
If the judgment debtor pays 10 lakhs, I will grant you easy installment for the rest.
My lord, I am telling your lordship, which cannot be done. Your lordship's order is absolute, my lord. No doubt.
Let the receiver go, take possession of the shop room, stop the business.
My lord, here is one submission, my lord. Senco Jewelers is no doubt running through a loss, no doubt. But one thing is that is century-old.
Absolutely. So he must, it must justice to its name.
It is not that there are so many Senco Jewelers, my lord. Senco Gold, that is not, I am not that. Senco Diamond, I am not that. I am simply my old.
I don't mind whoever and how many are there.
My lord,
only the judgment debtor. I will appoint a receiver to close his business.
My lord, I am submitting. They will, if the payment is.
Bring 10 lakhs.
My lord, it is impossible. I am telling your lordship, 10 lakh, they cannot do it. There will be tremendous prejudice to them. They cannot, they are suffering through loss, my lord.
Very well. Bring 10 lakhs.
My lord, my lord, at least by December, your lordship reduce it.
10 lakhs, 10 lakhs.
My lord, I am telling you, by March, April, May, I will clear everything.
By 10 lakhs by next week.
My lord, I cannot. My lord, I humbly pray your lordship.
Bring your client tomorrow. 10 lakhs, 10 lakhs.
My lord, I am humbly praying your lordship.
It is an execution court under the commercial division.
No, my lord.
Had it been in a regular suit, I would have been indulging. No question of indulgence. Come on.
My lord, it may be deferred, my lord.
Money, sir.
My lord, it is my appeal is pending. I am telling that appeal has not been reached.
Sir, you proceed with your appeal.
I have failed to bring any stay, my lord. That is fact.
Come and pay 10 lakhs next week.
My lord, it may be, amount is not much, my lord. Amount will be paid by March, April, May, June. Maximum June I will pay. But let it be started from January, my lord.
First 10 lakhs on the board.
First, my lord. Then, my lord, it will be very absolutely. It will
then I am appointing receiver. He will stop the business. He will take possession of everything.
My lord, at least, my lord.
I am appointing a receiver.
By December, 5 lakh. January, 5 lakh, my lord.
Next week, 5 lakh.
Next week, it is impossible, my lord.
Sorry, no. Next week, 5 lakhs.
My lord, it is impossible, my lord. And my lord, my three GS may be.
Yes.
3 GS may be disposed of.
By next week, 5 lakhs.
No. My 3 GS for which the date is fixed today.
Next week, 5 lakhs.
My lord.
Give me when, which day next week? Tell me. 5 lakhs.
By the end of November, my lord.
Receiver.
My lord.
Receiver will go take possession of stock and barrel.
My lord, as your lordship pleases, but...
Nothing doing. Ask your junior to take instruction over phone if the client is not present. That next week, 5 lakhs. Within next 10 days, 5 lakhs.
My client is here, my lord. I have brought him.
5 lakhs. Aaj ki baat?
Tuesday.
By Tuesday, 5 lakhs, which is Tuesday tarikh koto hocche? Tuesday tarikh koto?
25th, my lord.
25th.
25th now.
My lord, let it be 30th, my lord.
And by 10th, another 10th of December, another 5 lakhs. Then I will give you installment.
My lord, it will be tremendous hardship, my lord. As your lordship, I cannot say anything, my lord. But
Ask your client, then receiver will go take possession, lock, stock, and barrel by putting padlock. Ask your client, tell your client. Now likhiyo away.
actually, my lord, who will pay the receiver? That is also a pertinent question, my
That
lord.
you look out. Plenty will pay. Then it will be added to your cost. First you.
I am ready to pay.
So avoid the payment to the receiver. Better pay the plaintiff. Decree holder.
My lord, my representative of my client says instead of 25, it is to be 28th, my lord, only 2 days. Instead of by 25th, let it be, my lord, by 28th, only 26th, 27th. 2 days will and 28th. 28th, my lord.
28th 5 lakhs.
28th 5 lakhs.
And then by
mid of December,
by 15th of December 5 lakh. Ashur. This is an application filed by one of the directors, one of the alleged directors of the judgment debtor defendant judgment debtor.
The application is not by the judgment debtor, my lord.
Judgment debtor?
No.
That's right. Decree. I said decree director of. Wait. Ki bollam? Judgment debtor. The decree is dated.
Dated, my lord, 10th June 2024.
2024. For a total sum of rupees bold 20,50,000. 20,50,000. ঠিক আছে? 20,50,000. Along with interest thereupon at the rate of 12% per annum. What is his name?
This is Sarkar, Siddhartha Shankar Sarkar.
Your client's name?
Tumitendra Chandra Sen. Tumitendra Chandra Sen. S-U-M-I.
Tumitendra.
He is one of the directors.
Sri Shumitendra Chandra Sen, one of the directors of the judgment debtor, is present in court. Paragraph.
What I feel, my lord, his employee is there. Director is not present.
No, director is present.
Director is present.
My apology. I have not seen.
Full stop. The court raised a query to Mr. Siddhartha Shankar Sarkar, learned counsel appearing for the defendant judgment debtor, as to how soon the decretal dues can be paid off to the plaintiff decree holder. Paragraph. On instruction from his client present in court, on instruction received from his client present in court, comma, learned counsel for the defendant judgment debtor submits that the judgment debtor shall pay a sum of rupees 5 lakhs on or before November 28, 2025 in favor of the plaintiff decree holder. By fund transfer, electronic mode, and a further sum of rupees 5 lakhs by December 15, 2025 for the time being. Full stop. The payments shall be made by way of transferring the fund through electronic mode from the bank account of the by crediting the bank account of the plaintiff decree holder. Paragraph. The plaintiff decree holder, paragraph, through its advocate on record by way of a letter shall intimate the learned advocate on record for the judgment debtor defendant the particulars of the bank account where the fund shall be transferred. Poster. In view of the above, the matter shall appear under the heading to be mentioned. কিসে আছে এটা? To be mentioned on December 2, 2025. 2, 2025 to ascertain whether the first slot of payment has been made or not, as recorded above. Poster. Paragraph. Bas hoye gelo.
Well, 3 general applications, fate of the 3 general applications, that is by the
I will hear, don't worry.
for chamber application.
I will hear, sir.
If payment is already started, then there is no use of touching them.
No, I will not. If the payment is cleared, let me be very clear and candid to you. If the entire decretal amount is paid, then I will not proceed against the director. The application will be
My lord,
disposed of.
actually, that is, my lord, I am grateful, my lord. Actually, my application is for that.
Very well. For the time being,
they are protected by corporate veil, my lord. It is my submission.
Corporate veil.
Corporate veil.
All right. You make your submission on the next day.
My lord, if your lordship permits.
Corporate veil. Aki bollam. It is made clear that since an undertaking has been met, for payment on behalf of the judgment debtor defendant, এটা কি একসঙ্গে 3টে অ্যাপ্লিকেশন আছে? হ্যাঁ, একটা আইটেমই না পরপর, তাহলে একটাই অর্ডার হবে সব কটা। These applications shall remain pending for the time being,
my lord,
without taking any steps therein. Without taking any coercive step, দরকার নেই বলা, পেন্ডিং বলে রাখছি তো, shall remain pending for the time being.
This matter, in the true spirit, it is commercial matter, because when I sold the gold, it was 66,000, my lord, and today it is more than...
Next.
Item number 12.
My lord, 12, I am for the, my lord, judgment debtor. My lord would find from the last orders that the settlement is already going on and only 5 lakhs is remaining, which we will pay maximum 20 days.
My lord, item number 12, I'm for the decree holder, my lord. My lord, the decree was for an amount of 23,60,000. Out of that, a major chunk has already been paid by the judgment debtor, my lord. My lord, an amount of roughly 5.5 lakhs is pending, my lord, and they have promised to pay it by the next week, my lord. As such, I'm humbly praying that the matter be adjourned for a week.
Ashun, what's your name?
My lord, Akanksha Chaudhary.
MS Akanksha Chaudhary, learned advocate, appears for the plaintiff through virtual mode. Paragraph. Mr.
Parashar Boiddo.
Parashar Boiddo, learned advocate, appears for defendant judgment debtor. How many? One.
3. With along with the directors, it will be 3.
Defendants. Stroke judgment debtors. The parties jointly submit that lion's share of the decretal due has already been paid by the judgment debtor, and about a sum of rupees and about slightly more than a sum of rupees 5 lakhs is due and payable under the decree. Poster. The judgment debtors undertake to pay the same on or before?
Maximum 20 days.
No. She is saying 1 week. Tell me a reasonable time. Ajay Tarik koto.
My lord, today is 18th of November.
By November, sorry, by December 5.
Grateful, my lord.
By December 5, 2025.
My lord, another humble indulgence, my lord. There is only one judgment debtor, my lord.
Oh, judgment debtor. একটাই হবে, debtors হবে না। Defendants একটা, defendant একটা।
The company, my lord. Grateful.
The undertakes.
But kindly do not record undertaking, kindly directs. That will be more beneficial.
The judgment debtor submits that they shall pay the say now by such and such. The matter shall appear under the heading to be mentioned. On December
5th, my lord.
December 9, 2025.
Grateful, my lord. Grateful. Deeply obliged.
No, I am for the plaintiff opposing this application.
I am for the Union of India. My lord, this.
You are for the? What is the matter?
Well, this is Millard.
Take the microphone.
Millard, this is Millard an application Millard for them Millard for the respondent number 2. Millard seeking extension of time to file the written statement. Now, Millard, I find Millard.
Give me the list of dates.
The Millard kindly takes Millard paragraph.
I have not been served with the
application taken within 120 days.
Millard, the time has expired.
90 days also, Lord.
Within
90 days itself.
Millard kindly comes to Millard.
What is the delay?
Application? I have not been served with a copy.
You are not.
You are appearing for?
I am for the respondent number 1.
You have filed a written statement.
Yes. All
matter ends. How will he serve? Why will he serve you? You are a co-defendant.
Written statement. Actually, on the affidavit in opposition. I have filed an affidavit in opposition. Affidavit reply has been
affidavit in opposition to whose application?
To his application.
May I say, Millard?
Yes.
Millard, this is Millard he is Millard mixing with Millard another application. Millard, this is Millard an application by him, by the bank to
Not
file.
by him or
Millard,
she.
by the Axis Bank, the respondent number 2, to file a written statement, extension of time. Now, Millard, in paragraph 7, he has admitted that the time has expired on July 7. Now, Millard, from the my lord's court's portal, Millard, we find that Millard he has though Millard affirmed on 17th of July, but he has filed the application with the department on 2nd of August. If that is so, Millard, it's beyond Millard 120 days.
Let me see when the master summon has been taken out.
2nd of August. Yeah, from the case status, it is available. ওটা আমাকে এতে কর আমি কি বলে ওইটা বড় ট্যাবটা
1st August.
Yes, he has filed on 2nd August. 2nd August. If that is so, it's much beyond Millard 120.
120.
Much beyond.
Lordship, if I may, Lordship, the application, the written statement was filed within 90 days. The application was.
There is no provision for filing written statement within 90 days unless time is extended.
Yes, Your Lordship, the same was filed before the Lordship, with the leave of the coordinate bench.
Leave doesn't matter. Leave cannot override the statute. You satisfy me on law, matter ends. Give me the dates. When the plaint filed.
Lordship, the writ of summons was
4th December.
No, I am asking when the plaint was filed.
4th December 2024.
December, as my learned friend says.
4th December.
Your Lordship, I was in receipt of the
I'm coming, sir. 4th December
2024.
Plaint was filed.
That is what was falling from my learned friend.
When writ of summons was taken out?
I had received it on 9th April 2025, Your Lordship.
Writ of summons.
I have received it on 9th April 2025.
1 second. 9th April
2025.
You are for which defendant, sir?
Defendant number 2, Your Lordship, Axis Bank.
Defendant number 2.
Yes.
So your time starts running from 9th
9th
April.
April 2025.
So the 30 days comes on, tell me, upon calculating, Mr. Nirmalo Dasgupta, tell me when 30 days is expired.
9th May.
9th May, Your Lordship.
30 days, 9th May, calculate properly. You have not brought the list of dates. You have not brought the list of
His
dates.
application.
You are opposing.
Yes, I Millard, he has said that 7 July time has expired, Millard.
Staying will not do, sir. It's on record. A valuable right of written statement cannot be
9th May.
forfeited.
9th May.
9th May, very well. 9th May 2025, 30 days expired. When 120 days expires? Yes, Mr. Counsel applicant. When 120 days expired?
Lordship, now in between, Your Lordship, the defendant bank, since it's a bank, Your Lordship, they have a particular format of how they go through every summon that is received by them. So thereafter, they had approached me on 22nd May, Your Lordship.
Sir, you just tell me when the 120 days expired. Then you show me the law that bank is a privileged child under Order 8, Rule 1.
Copy not served, as far as Union of India concerned, as far as Union of India concerned, copy not served, regarding application other things, bank.
You are a co-defendant.
I am the main defendant.
You are a co-defendant.
I am the main defendant.
You are a co-defendant.
Co-defendant means?
মানে আপনিও কি ডিফেন্ডেন্ট ওর
Yes,
সাথে?
yes, yes.
সেটাই
So
বলছি।
you are not required to be served. You enjoy your presence, that's all.
July, Your Lordship. End of July, Your Lordship.
Huh?
End of July, Your Lordship.
Come on, give me the date. So vague.
কজ লিস্টে এয়ারপোর্টে ট্রান্সফার কর যশোরকে তুলে দেখিয়ে এটা কি পাঠিয়েছিস কে স্ট্যাটাস এখানে তো ইন্টারনেট খুলবে না নেটওয়ার্কটা অন কর।
What is the law, sir? What is the law?
File it within 30 days, and if not filed within 30 days, have to seek for an extension for filing it within the rest.
Within
90 days. Further 120 days.
So in aggregate 120 days.
120 days as a whole, Your Lordship.
So dates are material.
So, Lordship.
So you will not bring a list of dates.
Lordship, I had it, but it just ended right now.
Court will wait for your calculation. When 120 days
that
stop.
end Millard 30th July.
30th July, Your Lordship.
Millard, he has filed on 2nd of August.
30th.
Now, Your Lordship.
Millard, case status, Millard. Millard,
Why should I look at your personal device? What is there? I
get a printout. I have a printout from
It's 120 days expires on
30th July. 30th July, Your Lordship.
30th July 25.
25, Your Lordship.
Expires. Very well. When you have taken out,
Your
filed
Lordship.
the application, 2nd August.
Your Lordship, it was affirmed in July, 17th July, Your Lordship.
I am
but
coming, sir.
thereafter-
Hmm. Yes.
Your Lordship, the defendant number 2 had approached us on 22nd May, Your Lordship. And thereafter, after during the vacation, we could not. And thereafter, on reopening, we had entered appearance by filing Wakalatnama on 9th June, Your Lordship. And thereafter, the matter was taken up on 12th June, wherein we were first came in picture and we had represented. And thereafter, Your Lordship,
When leave was granted to you?
Lordship,
When leave was granted to you
for extension of time, Your Lordship, we did
for submitting the written statement.
for submitting written statement, Your Lordship, we did not get a chance to seek for a leave, Your Lordship.
বলছে এই বললে leave দিয়েছে?
Lordship, it was filed in the court, Your Lordship, with the leave. Leave stating that
When?
should that date. Your Lordship, if I may come back, Your Lordship,
Na, cannot.
because I have a note of it, but I cannot find it right
No,
now,
there
Your
is no
Lordship.
formal leave.
If Your Lordship would kindly keeps it tomorrow, I shall come back, Your Lordship. Because I have made a proper note and a list of it, and it's just not there in the record, Your Lordship.
Ex facie Millard, he is not entitled to.
It's praying for a
But
day's
this is the
leave,
fiat
Your
of the
Lordship.
written statement, there is no leave granted. It is beyond 120 days.
Just praying for a day's motion, Your Lordship.
He's coming back for a
The
day.
master summons has been taken out on August 2, 2025 with a prayer for extension of time to file written statement beyond 30 days. Full stop. Paragraph. On the basis of the submissions made on behalf of the parties and on the basis of the available records, the relevant facts are stated. Only the relevant facts are stated. Paragraph. On December 4, 2024, the plaint was filed. Full stop. On April 9, 2025, the writ of summons was received by the defendant number 2. আচ্ছা এই উপরে লিখুন this is an application কি লিখেছেন by the on to such and such by the defendant number 2 with the press such and such হ্যাঁ তবে কোথায় শেষ করেছেন বলুন writ of summons was received filed এটা full stop on এই ডেট গুলো বোল্ড করবেন the mandated 30 days under the amended provision of Order Roman 8, Rule 1 of CPC expired on May 9, 2025. Full stop. The mandated 120 days thereunder has expired on July 30, 2025. এটা কে রিপোর্ট দেবে বলো তো অ্যাকচুয়ালি ডেট গুলো শেরিফের রিপোর্ট নেব রিট অফ সামান্স কবে সার্ভিস হয়েছে হ্যাঁ কারণ একটা ভ্যালুয়েবল রাইট তো এইভাবে উড়িয়ে দেওয়া যাবে না যখন এখানে ডাইসি একটু
I have the mode of service given by the series department.
কেন তো ডেপুটি শেরিফ রিপোর্ট দেবে
This is the report.
এটা কোথায় অ্যানেক্স ওয়্যার
No, this is with the correspondence.
আচ্ছা নো বাট হ্যাভ ইউ annexed it in your opposite oh you have not got any opportunity
9th April. Mode of service.
ও আচ্ছা পরেরটা D1 very well I'm calling for a report because something should be on record full stop in view of the above the office of the deputy sheriff and the office of the learned master shall submit reports
No,
with regard to the
the first column says served on
I've seen defendant
Subrata
number one.
Goswami, yes, 9th April.
I've seen sir I've seen but something has to be on record if I have to shut out the written statement কি বললাম with regard to the actual date of service of writ of summons and the actual date of filing of the instant application by the defendant number 2 on the next day. Paragraph আজকে কত তারিখ
18th.
The matter shall appear under the heading কিসে আছে new chamber application on November 25
Grateful, Your Lordship.
2025
I shall assist, Your Lordship.
আচ্ছা মাথার উপর লিখুন মিস্টার নির্মাল্য দাশগুপ্ত লার্নেড কাউন্সিল লার্নেড অ্যাডভোকেট অ্যাপিয়ার উইথ না অ্যালং উইথ হবে উইথ নয় কিন্তু শুধু মিস্টার নির্মাল্য দাশগুপ্ত লার্নেড অ্যাডভোকেট অ্যালং উইথ এমএস প্রিয়াঙ্কা ধর লার্নেড অ্যাডভোকেট অ্যাপিয়ার্স ফর দি প্লেন্টিফ মিস্টার ইয়োর নেম
Shaunak Banerjee.
Shaunak Banerjee learned advocate appears for defendant number 2
Your Lordship.
Mr.
Mitra is also
Kumar Chakraborty with
Kollam Kumar
Chakraborty.
Chakraborty learned advocate with Mr.
Saurabh Sengupta.
Saurabh Sengupta learned advocate appears for Union of India. আচ্ছা ওইখানে কি লিখেছেন Mr. নির্মাল্য দাশগুপ্ত প্রিয়াঙ্কা ধর and Mr. Ranjan Lal Mitro learned advocate ঠিক আছে সব রিপোর্ট দিক না instant application and the date of submission of the written statement with whose leave you have submitted
With the coordinate benches leave, Your Lordship.
all right instant application filed by the defendant number 2 and the written statement allegedly submitted holo the original written statement shall also be produced before this court.
I'm enjoying otherwise an interim order which is expiring today. My lord, I mentioned today morning upon notice.
That is in connection with
my lord, item number 34.
34. Wait, 34 I might call. If I cannot call, then but you don't have to come. Your junior will take care of.
No. একই তো
Sir? Yes, if I cannot reach, then at the time of rising.
I will assist your lordship on the other day.
Bring a list of dates, sir. Yes.
My lord, it's my application. My lord, may I allow him to place this? He was very keen to do it, and both Mohit and I decided that our juniors will do it.
Welcome, welcome.
Junior to address your honor.
Yes, welcome.
Your Lordship, this is our application for continuation of delay in.
Take the microphone.
Your Lordship, this is our application for continuation of delay in filing of written statement.
Beyond 30, within 120.
Yes, Your Lordship.
What are the dates?
Your Lordship, the plaint was initially filed on 20th of December 2024. Thereafter, it was served on us on 18th of March 2025. Now, our written statement was affirmed on 22nd May, but it was filed on 25th June, which is the 99th day from the date of service of plaint. Thereafter, our application was filed on 2nd of July 2025, which is the 106th day from the service of plaint.
2nd July.
Yes, Your Lordship.
Written statement filed in May.
No, it was filed on 25th of June, which is the 99th day.
Filed on?
25th June 2025, Your Lordship.
With the leave?
Yes, Your Lordship.
Without the application being on board?
The application was filed a week thereafter, Your Lordship, but...
So satisfy me that that is permitted.
Your Lordship, so...
Lordship, you've noted this in your order of the previous date, if you could see that. On the...
You are for?
The plaintiff, Your Lordship.
There was an order to get the.
Yes, please.
Yeah, Your Lordship, in the order of the previous date, it's
Take the microphone properly and address in your own way, not to worry.
Your Lordship, in the order of the previous date, you've noted that upon the expiry of the 30 days mandate, under Order 8, Rule 1 of the CPC as amended, the matter was mentioned before the coordinate bench on behalf of defendant number 1 on or about May 23rd, 2025, when leave was granted by the coordinate bench to file written statements subject to the outcome of this application. So it's been noted, Your Lordship.
That is a whole point, Your Lordship. The written statement has been taken on file, taken by the department, but it is not a part of the record of the case. It is only subject to the application being allowed by Your Lordship.
So take Order 8, Rule 1.
Lordship, our contention is that no prejudice would be caused to the other side because we are anyways within 120.
It doesn't matter. The prejudice really doesn't matter.
Your Lordship, the application which will be decided by Your Lordship is what will decide my right to whether I'm allowed to file the written statement or not.
Kindly come to Order 8. Read.
May I read it, Your Lordship?
Yes.
Order 8, Rule 1. The defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense, provided that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing and on payment of such costs as the court deems fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record.
So what is the condition precedent?
So, Your Lordship, as if I may read, right, the defendant shall be allowed to file the written statement on such other day as may be specified by the court. So, we have only filed it on the department, Your Lordship. It is not kept with the record of the court. It is only on leave granted. So, for that, our application for continuation of delay should be the date on
which the leave will be granted.
Lordship, on the date of the application, Your Lordship.
On which?
The leave will be granted for the filing of the written statement, Your Lordship.
Upon being satisfied with the grounds. The court will, where from it will read the grounds?
From the application, Your Lordship.
So if the application is not there, how leave could be granted? That's my question.
Your Lordship, we have filed the application on the 106th date.
Day does not matter. What matters, first application, then leave, then filing of written statement. So without the application not being there, how an application can, a written statement can be taken on record?
That is our whole contention, Your Lordship. It has not been taken on record. It is still to be taken on record.
Why then how the court will grant leave also?
Now, Your Lordship, on the 106th day, when the application was filed in the court, right, Your Lordship would have the would have the application on record.
So it was application filed on when?
On 2nd of July 2025.
And when the leave was granted?
The leave was granted 7 days earlier, Your Lordship. The leave was granted to file the written statement subject to the outcome of the application.
Better do after some time. Mr. Pronit Bagh will be arguing one matter. Right? Let me decide that, then the series will be decided. And if on কবে রেখেছি ওটা প্রণীত বাগের ম্যাটারটা?
My lord, only one thing. In this case,
না শুনবো.
only one thing. In this case, there's a period of 30 days and 90 days. Now, 30 days, within 30 days, we have not filed.
I admit see my orders and judgments. Have you read?
I've read.
There are two, one big one and one small one.
I've read the big one.
The smaller one is also there. Take down, read it.
Now, in this case, my lord.
Wait. Why I'm saying reason is there. Take down this one also, note down. GACOM 1 of 2025. CSCOM 44 of 2025. 44. CSCOM 44 of 2025. 11 November 2025. I admit that till 120 days you have a right to claim extension upon showing sufficient reason. I admit that. But my confusion is there where unless the application is on the board,
Yes, my lord.
Can I grant you leave?
No, my lord. Here in this case, what has happened? I understand what my lord, what's running, my lord. Now, leave has been granted to file subject to the application.
If the application is not there, can I do that?
My lord, till then, therefore, it will not be treated as if it is in record. It is merely in the file.
Doesn't matter whether the jurisdiction of the court is there or not.
I will not get the benefit, my lord. Kindly appreciate. I will not get the benefit. Say suppose, for example, this was something, a leave had been granted on the 119th day. Possible?
The application comes
subject. The application comes after 7-8 days. Then it would have made a difference to me. Now here, I am filing.
Sir, leave will be granted upon being satisfied with the reasons shown. So unless the reasons are before me, how can I?
My lord, here there's a slight difference. Slight differences.
I can understand two things. The application has been filed. It is on the board. The written statement has been submitted with the leave,
system.
And then on the next day I hear.
That is the usual system. That is what it is.
All right, you come on that day. Let me do that matter. Then what will happen will happen. Then
no, probably my matter might be different from the matter my lord is talking about. Here, I am not saying that my lord counts my delay from that 99th day. I am saying
the moment I will accept this proposition, then where will be the bar in accepting that proposition?
No, that proposition there is a bar, because there it's the written statement that has been filed is never going to be treated as a part of the record, as if it has been
show me in the rule that I can do that.
Written statement has been accepted.
Show me
which is why I am not going into that.
Show me the rule.
My lord, which is why I am not going into that. Which is why I am saying on the 107th day, when I have made the application, let it be treated as the written statement has been filed.
Satisfy
on that
me on the point that even if the application is not on the board, I can pass an order of injunction tomorrow. Satisfy me on that. Then when the application will come, it will relate back to that date of filing.
My lord, to that extent, my lord, by giving me that leave of filing that written statement also, I am not benefited. Even this order hasn't benefited me to even one extent.
No question. Question is whether the court has jurisdiction to touch.
But the court has jurisdiction on after that application has been filed. So if that document is there, if my lord treats that as it has been filed from the 107th,
how do I know that? What is your reason?
that is on paragraph 5 of my application.
So the application first come, then the whether leave will be granted. So the cart cannot be placed before
What
the
has
horse.
happened in this case was at that point of time.
Try to come on that subsequently. We'll see. Next.
My lord has kept it on state, my lord.
কবে মনে পড়ছে না দেখে নাও 27-11 বলছে চান্স আছে
24th I am not there, my lord. That is
doesn't matter. That accommodation will be always there. And in any event, no, today I'm not passing any order.
My lord, some order may be passed for
এটা কবে দাও Yes, এটাই এটাই ঠিক আছে আসুন since an application involving an identical issue is already fixed for hearing on November 27, 2025, this application shall also appear under the heading New Chamber Application on the same day. এটা ওকে দিয়ে দিন বিপুলকে দিয়ে দিন I am on the legal proposition. I'm not on fact.
I completely understand the proposition, my lord. But today, if the court has given me leave, I can't be non-suited because of that.
No, of course. Of course you can be. If necessary. Yes.
My application is there on the 107th day.
No.
And if I show
then you have to file, you have to first move the application. As of now, my thinking.
Yes.
Upon reading order 8.
No, I also agree on this.
Then
I also agree on this, my lord.
If the application is not there on the board, one should not mention even.
No, my lord, these matters were being heard.
Very well. Let's see.
I will on the link next.
Get ready. Bring judgments, whatever way you want.
My lord.
এটা মাথায় রেখো তো 27 নভেম্বর আছে এরকম অ্যাপ্লিকেশন গুলো ফেলবো
My lord, my application to disclose disclosure of additional documents at the stage of evidence in a commercial suit, my lord. I am for the defendant in the suit, my lord. My lord, after the suit was filed, an application
at the stage of evidence.
My lord, his witness has
framing of issues.
My lord,
permitted.
My lord, for reasonable cause. If my lord
show me the provision,
my lord, kindly
in a commercial suit.
Commercial suit, my lord.
Show me the provision.
My lord will kindly see Order 11, the Commercial Court Amendment, Rule 10. Commercial Court Amendment
Order 11.
Rule 10, the Commercial Court Amendment, my lord. If I may place it.
Wait. Discovery and inspection.
Discovery by, initially it was discovery by interrogatories, the commercial
No,
court
Rule
amendment.
10, Rule 10.
Order 11, Rule 1, Sub Rule 10.
Say that.
My
Wait. Rule 10.
Sub Rule 10.
শোনো একটা একদম লেটেস্ট সিপিসি আনতে বলো তো। না এটা তো আছে 23-এর। না ওটাও তো পুরনো, ওটা আমার আছে বাড়িতে, পুরনো।
Also the 23 version.
হ্যাঁ রেখে দাও, ঠিক আছে। ইবিসি আনতে বলবে, যাই বই আনতে বলবে না, ইবিসি।
My lord, save and except for sub rule 7C3, defendant shall not be allowed to rely on documents.
You are for the?
I am for the defendant, which were in the defendant's power, possession, control, or custody, and not disclosed along with the written statement or counterclaim, save and except by leave of court, and such leave shall be granted only upon the defendant establishing reasonable cause for non-disclosure along with the written statement or counterclaim. So the discretion is with your lordship. For reasonable cause, your lordship may permit.
Show me 7C3.
My lord, 7C3, my lord, will go
Yes.
little up.
Yes.
Should witness to refresh his memory, my lord.
Yes.
So, my lord, I will humbly submit that my lord has the power, subject to my lord being satisfied that I have made out a reasonable cause for being unable to produce along with my written statement. My lord will kindly see my application. My lord, this was a suit which was primarily for unpaid price of goods. They had filed the suit for unpaid price of goods, had made out an admission of a amount.
How many defendants are there?
My lord, there are 6 defendants, my lord. I am for 1 to 5. The claim is really against the joint venture, which is defendant number 1.
Take the microphone, take the microphone.
The claim is really against the joint venture, which is the defendant number 1, and the company, which is the defendant number 2. So they say that they
are the rest of the defendants involved?
My lord, one of them is a partner in the joint venture. Not one of them, 3 of them are partners in the joint venture, my lord. So they have been made parties, my lord.
So clubbing these 5, file this application.
My lord. Because our defense is the same. One of our primary defenses is when the invoices were raised, most of the invoices have been disclosed in the plaint as well as along with the written statement. The invoices were accompanied with weighbridge slips or cutter slips, from which the weight of the actual consignment received could be made out. So one of our defenses is that there was overcharging. Whereas from the weighbridge slips, it appeared that a lesser amount has been supplied. The invoices mentioned a higher amount.
Let them file affidavit.
They have already, my lord. Affidavits are complete.
Affidavits have been exchanged.
Affidavit file.
Affidavits are complete, my lord. It is appearing as adjourn motion, my lord.
Yes. Reply is not there in file. See?
But I'll check. Kindly gives me a minute. The reply was filed.
Served.
Served in time. My lord, the reply is.
Ashu.
Reply it. File করেনি.
No, opposition. This is an application
Served reply.
filed by the defendant numbers 1 to 6.
1 to 5. 6.
লেখা রয়েছে 6.
My lord, really want to. My lord says 6 since it's really 1 to 6. My lord, in the application, it is defendants number 1 to 6. Humble petition of the defendants 1 to 6.
That's right.
All the defendants.
My lord keeps it 1 to 6. My lord.
Defendants, all 6.
All defendants.
কি বললাম? Filed by the defendants. Inter alia praying for notice the motion টা দাও. Opposition দাও. Where is the opposition?
I have filed the opposition.
আচ্ছা, opposition reply. চলো, ইয়ে দাও. Inter alia praying for leave to disclose documents being annexure K to the application by filing additional judges briefs of document, judges brief of document, apostrophe S, judges brief of documents.
My lord, may I interrupt once? Annexure K is the list of invoices and annexure L are the actual documents. 50 weighbridge and
documents কতটাকে রাখো, annexure being annexure টা বাদ দাও. Your prayer is only for K.
My lord, if my lord is pleased to allow K the
চলো, ঠিক আছে. Annexure L, annexure documents করে ছেড়ে দাও.
K is only a chart actually.
Documents, কি বললাম? Leave to disclose the documents mentioned in the application, leave to disclose further documents.
Additional documents.
Further documents. Full stop. Affidavits are exchanged. Affidavits are filed and exchanged by and between the parties. Paragraph. On the prayer of M.S. Hashnu Hana Chakraborty, Learned Counsel appearing for the defendants. Time to file affidavit in reply stands extended till today. Full stop. The affidavit in reply filed in court today is taken on record. Copy has been served upon the plaintiff. Yes. Proceed.
My lord, these are weighbridge slips from which it will appear that the actual weight of the materials which was supplied.
I'm not on merit, not on merit,
my lord,
not
it
on
is
merit.
I absolutely
I don't
appreciate
require to know that. I only require to know whether you were prevented by sufficient reason or not. That's all.
Absolutely. I only said that to substantiate that the documents are relevant documents. Absolutely.
Immaterial. If I find, madam, that the reasons are sufficient for non-disclosure, I will allow.
My lord takes up.
What will happen to the document, it's a matter of trial.
Ultimately trial.
You may succeed, you may not succeed. Up to you.
My lord,
It's up
kindly
to on the
comes to
merit of the
paragraph
case.
16. Paragraph 16 is my reason. Page 6, paragraph 16. If I
Paragraphs?
Page 6, paragraph 16, and the sub-paragraphs thereunder. My lord, if I may place paragraph 16. At the time of preparation of the affidavit of examination in chief of the defendant's witness, the following transpired. In order to substantiate the case of the defendants, that short supply of materials were made by the plaintiff to the defendants were relying upon weighbridge slips and or kata slips annexed to the invoices raised by the...
Immaterial.
My lord, I'm making out the call. My lord, kindly bears with me for a minute.
I don't require to go through the document what you want.
I'm not taking your lordship through the documents, my lord. Kindly seize B.
Even if you want to disclose an irrelevant document,
but I'm not on the relevance, my lord. I'm not on the relevance.
At this stage, because I cannot go for a mini trial.
Absolutely not, my lord.
So just show me the reasons.
My lord, B. It, however, came to the notice of the defendant's witness that some of the invoices disclosed did not have the weighbridge slips and or kata slips appended to them. Mrs. So-and-so, the so-and-so of the defendants who was entrusted with looking after the legal cases of the defendants, including the above suit, had left the services of the defendants on or about November 30, 2024. And as such, the issue as to why the weighbridge slips and or kata slips had not been annexed to some of the invoices could not be clarified from her. However, since the defendant's witness had personally dealt with the matter, he was aware that the weighbridge slips and or kata slips were appended to all the invoices. A list of the invoices which did not have the weighbridge slips have been annexed. The defendant's witness, Mr. So-and-so, conducted extensive search at the various offices of the defendants, including at its office at so-and-so and so-and-so. After extensive search, the original weighbridge slips and or kata slips appended to the invoices mentioned in annexure so-and-so were discovered at the office premises. Particulars which were not disclosed earlier are given. So, my lord, about 500 invoices are there. With 450 invoices, kata slips were there. At the time of filing his evidence, he went through all the documents, found that 50 of the invoices did not have the weighbridge slips. Could not find them. He searched all his offices, found the 50 and came up before your lordship, my lord. These documents could not be located when the written statement was filed, my lord. All the other relevant documents have been included with the written statement. These are also annexed to the plaint. And then, my lord, we say that these are relevant documents. My lord, the law, my lord, is that if this is a reasonable cause, I say this is a reasonable cause, because, my lord, these were at that point of time not found, my lord. They were not in my possession. I had to conduct search and find this out. However, my lord, I will not put my case as these were not in my possession. At that juncture, it could not be located, my lord. Because, my lord, these were in my possession, although, my lord, I was not aware of their location, my lord, I have to show reasonable cause. My lord will kindly see, well, it is not as if I have prayed that these are voluminous documents and I will not disclose. Why I said that, my lord, one judgment which is relied on, my lord, by both the parties is Sudhir Kumar versus Vinay Kumar. Reported, my lord, in 2021, 13 Supreme Court cases, 71.
71.
71. 2021, 13 SCC, 71. Well, this was an application by the plaintiff for disclosure of additional documents, my lord, in a commercial suit. My lord, sees 8.4. Here, documents were of two kinds. One was not in the possession of the plaintiff. The other set was in the possession of the plaintiff, but the plaintiff said they were too voluminous and hence I did not include them. My lord, all the observations and, my lord, all the judgment is in that background. 8.4, it is further submitted that as such the application submitted by the plaintiff lacked bona fide as having realized during the course of hearing of the interim injunction application under Order 39, Rule 1, that non-production of the documents which subsequently are sought to be produced may come in their way, and the interim injunction application was kept for orders as an out. Well, it is then further submitted by the learned counsel appearing on behalf of the respondent herein, original defendant, so far as the cause reason shown in not producing the additional documents other than the invoices, namely, as the documents were bulky and therefore they were not produced. This is the reason that is shown for non-production of documents in the possession of the plaintiff. My lord will, my lord, then Order 11, my lord, is analyzed, my lord. My lord will.
1 second.
My lord, it is not as if that if
Yes, next.
my lord, paragraph 9.6, my lord will take from therefore order 11 rule 1 sub rule 4 and order 11 sub rule 1 sub rule 5 is applicable to the commercial suit shall be applicable only with respect to the documents which were in plaintiff's power, possession, control or custody and not disclosed along with the plaintiff. Therefore, the rigor of establishing reasonable cause in non-disclosure along with the plaintiff may not arise when the
This was for the plaintiff.
This was for the plaintiff.
This judgment was on the plaintiff.
For whom the tests, my lord, I would say, are stricter.
And this judgment was delivered in case of a plaintiff, but the provision is the one, order 11.
Order 11 is the provision, the common provision, and more or less the two sub-rules are parameteria. More or less they are parameteria. But the
parameteria,
more or less the disclosure rules in respect of plaintiff and the defendant are the same. Same.
That's why I'm saying
Plaintiff
provision is the single.
Provision is one.
It applies to the parties to the suit.
More or less.
Correct. Read on. 9.6.
Therefore, Order 11, Rule 1, Sub-Rule 4 and Order 11, Rule 1, Sub-Rule 5 applicable to commercial suit shall be applicable only with respect to the documents which were in the plaintiff's power, possession, control or custody and not disclosed along with the plaintiff. Therefore, the rigor of establishing the reasonable cause in non-disclosure along with plaintiff may not arise in the case where additional documents sought to be produced or relied upon discovered subsequent to the filing of the suit. My documents are not subsequent documents. I could not find them, my lord. My lord, kindly now my lord will take paragraph 10.4. Now, so far as the other documents sought to be relied on, produced as additional documents other than the invoices are concerned, the same stands on different footing. It is not disputed and in fact it was specifically admitted and so stated in the application that those additional documents other than the invoices were in possession but not produced being voluminous that the suit was filed urgently. However, it is to be noted it goes into the discussion and then my lord 7 or 8 lines from there my lord reads and therefore as such order 11 rule 1 sub rule 4 shall not be applicable though the application was filed within 30 days of filing of the second suit. While seeking leave of the court to rely on documents which were in his power, possession, control or custody and not disclosed along with the plaintiff or within the extended period set out in order 11 rule 1.4, the plaintiff has to establish reasonable cause for non-disclosure along with the plaintiff. My lord, then 10.5, in view of the facts and circumstances narrated herein above, and in view of the filing of the first suit in the month of so-and-so, the ex parte ad interim injunction in favor of the plaintiff dated so-and-so, withdrawal of the first suit and so on and so forth, non-filing of the additional documents other than the invoices on the ground of them being voluminous cannot be said to be a reasonable cause for non-disclosure or non-filing along with the plaintiff. My lord, I showed this judgment first because usually reliance is placed here to say that if the documents are not in your possession, then only you can disclose. Otherwise, you cannot. My lord, the law is, in my humble submission, if reasonable cause is shown, then I can disclose. And I have not said these are voluminous. On the other hand, my lord, voluminous.
So ultimately, here the prayer
Here it
was rejected.
because of voluminous documents, not
it is not that it was not in his possession.
Not in his possession, my lord.
It was in his possession, but because of voluminous, the reasonableness was not there before the court.
And it was admitted it was voluminous. In my case, it is just the opposite. Voluminous documents I have disclosed. Only 50 have been left out. My lord will kindly read this.
No, in your case, it was in your possession.
But could not be
but
found.
the defendant could not realize that these are to be disclosed.
My lord, and could not be found. These documents, my lord, I have also specifically said extensive search had to be conducted at my offices, and then I located these documents. My lord will kindly take another judgment. This helps me, although I place this thereafter, because 2020 10 SCC 706.
This is prior to comment.
Prior to, but my lord will now see it deals with production of documents along with the written statement. Order 8, Rule 1A. My lord, it is
Order 8,
relevant.
Rule 1A today is different after amendment.
Absolutely. But what the court had observed, my lord.
Yours is a commercial suit.
My lord, very true, but there good cause had to be shown. I have to show reasonable cause. I am
No doubt
relying.
about it, madam. That's the language of the rule.
Well, I'm relying on this.
Upon court being satisfied with the cause.
What was accepted as good cause? What was accepted as cause for allowing additional documents? This is what I am relying on. My lord, paragraph 2, the appellants herein are the defendants in the suit number so and so before so and so court, and the respondent is the plaintiff. For the sake of convenience, parties are referred to in their respective positions before the trial court. Plaintiff filed a suit for injunction alleging that the defendants are attempting to grab the scheduled suit property. When the suit was posted for evidence of the defendants, they filed an application seeking leave to produce certain documents. It was contended that they had recently traced these documents relating to the suit property, and that was why they could not produce them along with the written statement. Application was opposed. Then, my lord, Rule 1A is discussed. Kindly, my lord, sees paragraph 9. It is often said that procedure is the handmaid of justice. Procedural and technical hurdles shall 9.
Yes.
It is often said that procedure is the handmaid of justice. Procedural and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adversary party, courts must lean towards doing substantial justice rather than relying upon procedural and technical violation. We should not forget the fact that litigation is nothing but a journey towards truth, which is the foundation of justice, and the court is required to take appropriate steps to thrash out the underlying truth in every dispute. Therefore, the court should take a lenient view when an application is made for production of the documents under sub-rule so and so. Coming to the present case, the defendants have filed an application assigning cogent reasons for not producing the documents along with the written statement. They have stated that these documents were missing and were only traced at a later stage. It cannot be disputed that these documents are necessary for arriving at a just decision in the suit. We are of the view that the courts below ought to have granted leave to produce these documents. Well, and I am only on this part. What was accepted as a satisfactory cause in a case where I say the standard of test is higher than I have to satisfy here, my lord. Same case as I have made out. And I would humbly pray that these documents would ultimately, my lord, help in adjudication of the suit, because it relates to one of my primary defenses in the suit.
All right, you have completed.
My lord.
Huh? Any further?
Subject to what?
2 o'clock, I have a fixed matter, which may continue, which may not. I don't know. So if it does not continue, I will continue with this matter and complete, and then the next matters. I will follow the list.
Can it be humbly praying, my lord? Can it be tomorrow, my lord? Because I have a personal difficulty in the family, my lord.
You are not required to be here. Let him submit. You have made your submissions.
There's a bereavement in my family, actually. There's a bereavement in my family. There's a bereavement in my family. So there is a bereavement in my family. I leave.
Oh, bereavement in your family.
But my learned friend will continue. I'll give a reply on the next day if tomorrow, my lord, any day.
So come tomorrow.
My lord, grateful, much obliged.
MS Hashnuhana Chakraborty, learned counsel, আগেরটা তো লেখা আছে, appearing for the applicant defendants has concluded her submissions. Full stop. Paragraph. Mr.
Saurajit
Dasgupta, learned counsel appearing for the plaintiff, shall commence his submissions tomorrow. Full stop. Paragraph. The matter shall appear under the heading for orders tomorrow on কত তারিখ করে দাও, November 19, 2025. এটা আমাকে আর্জেন্ট আছে, এটা কালকে থাকবে তো ওই জন্য আজকে আগে করে দিই, এখনই করে দাও, আমি করে দেখে দেবো সেটা সার্ভার করে।
Grateful.
Would you rely upon some judgments?
One judgment, I'll give a copy to my learned senior friend.
Give it to her so that she can come prepared.
It's 16.
14 তো হয়ে গেছে।
Item
But I've
16
given
I have after lunch.
Not after lunch.
After
There is
2
a
p.m.
2 p.m.
I may get stuck, whatever. Then tomorrow my junior will be here.
I will hear the matter.
In item number
I'll hear
69,
the matter.
for the defendant, that Mr. Shobhoshachi Chaudhary is leading.
Doesn't matter, sir.
That he's not come to court today. That he's not feeling well. That he's down with fever.
If this is going on, why the juniors must proceed?
Shonak Mukhopadhyay is also briefed in this matter. Milord, I'm not briefed in this matter. Shonak Mukhopadhyay is briefed in this matter.
Juniors must proceed. Juniors must proceed.
I understand, Milord. I'm seeking, Milord, just a day's.
Then I shall have to adjourn the matter. I don't mind for that.
I am the plaintiff.
I will adjourn for in the month of January or February. The later part must give chance. They must be given chance.
Just a day's accommodation, Milord.
I will adjourn the matter. I don't mind in accommodation.
Lordship then does not.
I don't mind in accommodating, but equally the letter No,
appendix
this is not the time to mention. Sorry.
Extreme complex circumstances.
No. Next.
Petitioner's academic career is going to be ruined, my lord.
Next.
Only contempt application will be taken up, my lord. Let it be listed on Friday, my lord. Let it be listed on Friday, my lord.
Sorry, sir, I have said nothing doing.
Please, minutes. Because I'm being led by the learned advocate general, and while the learned AG joins me, I will start, minutes. Well, this is the matter where we'd filed an application seeking an unconditional stay on the operation of an award.
Yes. Just come on, make your submissions on the Supreme
Judgment.
Court judgment.
Please, my lords. My lords, so after my lords had reserved this matter for judgment, there is an important subsequent development which has happened where the Supreme Court of India has rendered a judgment on the scope and ambit of Section 36 of the Arbitration and Conciliation Act. My lords, now your lordship will recall that when we were addressing arguments on the scope of Section 36, my lords, our arguments were twofold, my lords. We had submitted before my lords that prior to 23rd October 2015, mere filing of an application for setting aside of an arbitral award meant a stay on the operation of the award. Now in 2015, please.
Hey, you go there.
Has it?
Yes.
No, greed for money. অন্য কোথাও গিয়ে একটু টাচ এন্ড গো করা যায় আর কি।
Yes, Mr. Advocate.
Yes,
Only
please.
on the judgment.
Yes.
Take me through the judgment. It is সরিয়ে রাখো একবার দেখে নি দাঁড়াও কিছু সরিয়ে রাখো এটা রেখে দাও
Namalad, if your lordship recollects, Milord, just half a minute on this. That, Milord, my section 36 was
36(3).
Yes, was premised primarily on 2 points. Primarily, one is that bias because the arbitrator, according to us, had somewhat connection with the Tatas. Therefore, bias is an element of fraud, and Milord, the second proviso of 36(3) would apply. This was one limb of my submission. The other limb of my submission was that irrespective of that proviso, Milord, section 36 also permits an unconditional stay in respect of a money decree. Or in other words, Milord, my respectful submission was that the expression in section 36 on such conditions, this phrase,
Yes, sir.
Milord, section 36 subsection 3 uses the expression subject to such conditions. Milord, my respectful submission was such conditions includes an unconditional stay. So unconditioned or unconditioned stay is also a condition.
Yes.
Well, we had relied upon judgments of various high courts. My learned friend, Mr. Sarkar, had also relied upon judgments, which were all high court judgments. But now we find, Millard, that the Supreme Court has also, Millard, considered this issue post, Millard, conclusion of hearing by your Lordship, Millard, which somewhat, according to me, subject to your Lordship's correction, is in the lines on which, Millard, I have argued the matter. Now, if you look, Millard, we have handed over a copy of the judgment.
It is all with me.
Now, please have a look to this judgment.
Yes, sir.
Now, here, my lord, I must first, my lord, draw your lordship's attention to the fact that this arises out of a suit. In a suit
of trademark.
Yes. Now, when the suit was decreed, then it goes up in appeal, and finally it goes
Decree for damages.
Yes. Now, my lord, finally it reaches the Supreme Court. Now, before the Supreme Court, my lord, parties had addressed the Honorable Supreme Court on the scope of Section 36. This is very important. Though it arose out of a suit, but, my lord, when parties, my lord, address the court on a particular issue, my lord, then the judgment is authoritative. It is not an obiter or a passing remark.
You have to, you argue in your own way. Take me through the judgment. But you will also have to argue that it is not an obiter, as you have canvassed.
Yes. Yes. Please take me, lord.
Even if
I'm sorry.
Even if it is obiter, then also obiter of Supreme Court.
Obiter of Supreme. Will your lordship may kindly take me, lord, paragraph 95.
Yes.
At this stage, we need to clarify something important.
Oh, just hold me. Yes.
Paragraph 95, at this stage, we need to clarify something important. At the outset, we must state that this litigation has nothing to do with Section 36 of the Act. In the present litigation, we are only concerned with Order 41, Rule 3 and 5, respectively of the CPC. We are referring to Section 36 of the Act only for the limited purpose of answering the specific contention raised by Mr. Gaurav Pachnanda. Or in other words, Millard, the Supreme Court was addressed in an SLP, Millard, arising from a suit on Section 36. That is why, Millard, the Supreme Court notes that it has got nothing to do with 36, but we are saying this because parties have addressed, one of the parties have addressed. Yes. In other words, whether the learned counsel is right in extending the analogy of Section 36 of the Act to the present case or rather to the provisions of Order 41 of CPC is inappropriate. For this limited purpose only, we thought it fit to look into two decisions of this court, one in the case of SEFCO reported in so-and-so and the other in PAM developers.
Now, 1 second.
Yes.
Yes. Yes, sir.
Well, while your lordship take up while your lordships will take up, Millard, an application under Order 41 arising from a suit, Millard, your lordships, Millard, do not look into the provisions of Section 36 of the Arbitration Act. Say a normal money decree between two private persons. And when the question of stay comes before the appeal court, first appellate court, then Millard, your lordships are not required to look into the Section 36 of the Act. But when your lordships are looking into Section 36 of the Act,
yes, the whisper is there.
Yes,
that
because
as a guideline
right,
you can follow.
Yes. So Millard, Order 41 then becomes a guiding factor. So Millard, in
directory.
Yes.
Directory.
Yes, definitely. All procedural laws, Millard, are directed. Therefore, Millard, this Millard Section 36 interpretation arising from a matter in a suit, but in my very respectful submission, would also apply in cases where the court is considering an application under Section 36 of the Act. PAM developers and all, Millard, are there. Now, we may skip over, Millard, paragraph 96. Then we have the history of Section 36 is at paragraph 97. We can skip over that also. Then para 98, the automatic stay, Millard, the Amendment Act, Millard, is also noted by the Supreme Court. I skip over that. Where I skip over 99 also, Hindustan Construction. Now, please take, Millard, paragraph number 104. 104 is the submission of Mr. Pachnanda, which is akin to the submission of Mr. Sarkar in this case. Mr. Gaurav Pachnanda, the learned senior counsel, would argue that courts cannot grant the benefit of unconditional stay of an award in cases other than those covered by the second proviso to Section 36(3) of the Act. In the same manner, according to the learned senior counsel, when it comes to staying a money decree unconditionally, the judgment debtor needs to make out more than a prima facie case of fraud or corruption or something analogous to the same, and it is just for just not sufficient to point out our serious infirmities in the judgment granting money decree. In the aforesaid context, we must look into the decision of this court in SEPCO. In the said decision, this court was dealing with an appeal against the judgment of a Delhi High Court, where the learned single judge had granted a stay of the arbitral award subject to deposit of 100% of the award money. This order was passed in an application under Section 9 of the Act, which was heard together with an application under Section 36(3) in a connected petition. This decision was affirmed in appeal by this court, which held that there were no grounds made out for interfering with the judgment below. This court, while considering the contention of the appellant therein, observed that a court may grant an unconditional stay if it is appropriate to do so. While so observing, this court stated that the unconditional stays were covered by the second proviso of Section 36(3). The relevant portion of the judgment are extracted below. May I skip over the quoted portion? Now please take 107. While this court acknowledged that an unconditional stay could be granted in appropriate cases, it quickly followed up by saying that the power to grant an unconditional stay is governed by the second proviso to Section 36(3). This may indicate that the court acknowledged the grant of an unconditional stay to the existence of the grounds mentioned in the second proviso. This would indicate that the benefit of unconditional stay could be granted only in cases of fraud and corruption. The previous view. Notwithstanding the above, so what was the view, my lord, prevailing as on the date this judgment is passed? According to the Supreme Court, unconditional stay only if the proviso is satisfied. Second proviso.
Fraud and corruption.
Fraud and corruption. Now, keeping that in mind, my lord, the Supreme Court proceeds. Notwithstanding the above, this court, in order to fortify its conclusion in the case, subsequently also noted that the appellant therein was not able to show any cogent and glaring error that went to the root of the award. This observation was repeated later, where the court stated that no cogent ground has been made out, even prima facie, for interference with the impugned award. The relevant observations are extracted below. Where I skip over, my lord, the observations over there.
No, the moment it is interference with an award, it is only and only the 34th stage.
Yes.
The moment it is an interference with the award, it is only and only at the 34th stage.
Yes. Yes. 30, my lord, I can, now of course, my lord, Supreme Court says that even without a 34, you can move an execution application. Supreme Court says that without even a 34, you can move an execution application, if, I mean, before the expiry of the period.
Can't follow.
34 has a period. During pendency of 34, 36 is applicable. Usually what we do is we wait for the period for filing of Section 34. After the period of say 90 days plus 30 days is
Then
over,
execution.
then execution.
Now you're saying even
because
within...
even before 34 is filed, you can go for an execution. Be that as it may not be applicable in our case. But so far as 36 is concerned, 36 is preconditioned by saying that once 34 is filed, then of course you can go for Section 36, ask for whatever you.
Unless 34 filed, 36 not applied.
Because the reason being, 36 only defers the enforcement of the award in the mechanism which is provided in 36. Well, I skip over, my lord, paragraphs 109 and 110. Now, please take, my lord, 111. In the light of the above mentioned observations, it is possible to legitimately argue that if the second proviso to Section 36(3) was the sole source of granting an unconditional stay, there would have been no occasion for the court to examine whether any prima facie cogent ground that went to the root of the award is forthcoming or not. Therefore, by relying upon this court's observation, it could be plausibly argued that in exceptional cases, an unconditional stay can be granted even in cases not arising under the second proviso to section 36(3). Such unconditional stay would instead be relatable to the main part of section 36(3). Kindly recollect, my submission was all through that unconditional stay is not confined to only the proviso. If I can make out an exceptional case, but in fact, fortunately, the Supreme Court uses the same expression. If I can make out an exceptional case for grant of unconditional stay, the court is not powerless to grant that. The court will not merely look at that second proviso and say that, sorry, your case does not fall under this exception, therefore the court is powerless to grant an unconditional.
In the instant case,
yes,
which we are dealing with,
yes,
if prima facie it is found, as you have argued, that biasness is there, and bias being an element of fraud, then unconditional stay permitted. So the moment a prima facie finding is found, it also becomes an exceptional case. It also becomes an exceptional case for granting unconditional stay. Now, other than this prima facie finding for fraud or corruption, many factors may be considered to the court as exceptional. Many factors may be. It's the perception of the court that this is an exceptional situation. You are saying that even if we don't look at the expression fraud and corruption, if a prima facie exceptional case is made out, which is also exceptional to the court, then even if fraud and corruption is not there, it is permitted.
Yes. But I can, for the present, give your lordship an example. Like I come and demonstrate before the court that the arbitral award was not written by the arbitrator himself. He may have engaged his brother, sister, wife, whoever who had drafted it, he just merely signed it. I come and tell the court that though he has signed it, he has not applied his mind. Look at this, I have got a handwritten copy of the person who has written it. Therefore, I come and tell this court that the arbitrator did not apply his mind. And come and tell your lordship that this is an exceptional case, which will not come under fraud corruption. It is not fraud corruption. It's not bias. Maybe a justified award, correct award. My case over here is one of the facets of my case, apart from this fraud corruption, was perversity. 250 crores of my counterclaim, 5-line paragraph, finish.
One line. And Bombay High Court considered the circumstances unconditional. Examples we gave from Bombay.
And my lord, your lordships have those judgments which I have relied, where my lord, on this ground, Bombay High Court has granted unconditional stay. So these are, my lord, exceptional circumstances, or that, my lord, we can point out. And if the court is satisfied that what we are submitting is correct, my lord, this, the court is not powerless in these circumstances to grant unconditional stay. Now, my lord, if I may read further, my lord, one more paragraph, one or two more paragraphs. Para 112. The above reading of SEPCO would also be in tune with the discretionary power of the court under the main part of section 36(3), both with respect to the power to grant stay and power to impose conditions if a stay is granted. After all, it is not inconceivable to contend that the power to impose conditions would also impose the power not to impose conditions. This is exactly what I said, argued rather. I had put it in a different way. Such conditions includes no condition. But all along the interpretation was such condition means you have to give some condition. Then Miller paragraph 113. Be that as it may, SEPCO does not clearly answer the question whether an unconditional stay can be granted in cases not covered by the second proviso to section 36(3). This confusion remains because while the court states an unconditional stay can be granted in cases covered by the second proviso, it does not categorically exclude the possibility of an unconditional stay in cases not covered by the second proviso. But Supreme Court adds one more thing which I did not argue, that unconditional stay is not categorically excluded. Therefore, my lord, this judgment has three basic points. One is, in an exceptional case, you can grant unconditional stay.
Yes.
But number two is, power to impose conditions include power not to impose conditions.
Yes.
And number three is, the statute just does not specifically exclude conditional stay in this section, or not covered by the second proviso. Therefore, such conditions includes no condition. This was my submission, where I rely upon this subsequent Supreme Court judgment in support of my submissions.
120, 22, 24.
Yes. Now, my lord, PAM developments.
Yes.
PAM developments is also frequently cited. On this point, that unless under the second proviso, nothing. Kindly similar, now Supreme Court has considered PAM also in para 120. PAM is also been given
PAM was more on security, furnishing security.
Yes, right. Now kindly see, my lord,
under CPC.
Yes, Supreme Court reads into PAM unconditional stay.
Yes.
My lord, 120. If the first proviso has to be interpreted as done in PAM, and merits of the award have to be considered on a prima facie level as done in SEPCO, it is difficult to rule out the existence of an unconditional stay in cases outside the second proviso. A closer analysis of the decision in SEPCO and this court's interpretation of the first proviso in PAM suggests that unconditional stays can be granted even in cases outside the second proviso. Yes. So why do I need to show fraud corruption? It's PAM is according to the subsequent decision, of the Supreme Court, PAM itself contemplates an unconditional stay in the first proviso itself. Also, we have taken advantage of PAM saying that I've also taken advantage, but now the Supreme Court clarifies the situation. We had a later judgment of the Supreme Court considering a previous judgment, where the later judgment is authoritative. So, considering PAM, Supreme Court says that unconditional stay can be granted outside second proviso. Now, please take 122.
122. Yes.
In such circumstances referred to above, we find it difficult to subscribe to the submission of Mr. Gaurav Pashnanda that even for the purpose of grant of benefit of unconditional stay of money decree under Order 41 Rule 5 of the CPC, the judgment debtor has to make out more than a prima facie case of fraud or corruption, and not solely on the basis of extreme or egregious view of the merits of the adjudication. Then last, 124. We are of the view that if fraud or corruption or something analogous to the same is only to be seen for the purpose of granting the benefit of unconditional stay of execution of money decree, then in such circumstances the decree holder may argue that although there may not be a valid service of summons to the defendant judgment debtor, yet the same by itself will not be sufficient to grant the benefit of unconditional stay of execution of the money decree. This would lead to nothing but serious miscarriage of justice.
Nothing but?
Serious miscarriage of justice. But the last sentence which I have pointed out is the clincher, Millard, so far as my case is concerned. But if the court keeps itself confined to the second proviso only, while 124, the last sentence.
This would lead. No, before that.
Yes, ma'am. It starts with this would lead.
This would lead to nothing but serious miscarriage of justice.
Egregious things I've shown from there.
So this non-service of writ of summons was accepted as an exceptional circumstance.
Right. But exceptional circumstances.
It's a perception.
It's a perception. I have tried in my own way, Millard, to demonstrate before your lordship. I'll not trouble your lordship with by reopening my arguments. But twofold submission was: number one, bias fraud. Number two was, assuming there is no bias fraud, your lordship is not with me on that. Then also, Millard, in exceptional cases, Millard, unconditional stay can be granted. Now, Millard, I would now venture to argue that since the parties have addressed, Millard, the court on this, and I mean,
not the issue before the court.
It was not the issue before the court. but parties addressed, and the Supreme Court entertained the parties in addressing the court, spent judicial time in hearing, and Millard
gave its reasons,
gave its
finding.
reasons elaborately, not a mere passing remark. Now, in the passing,
its finding.
Yes, one sentence or half sentence. This is not a case like that. Therefore, Millard, I would respectfully submit, Millard. If your lordship invites me, I can definitely address that this is not an obiter. Even if it is an obiter, it is binding. But I have those judgments subject to your lordship's pleasure.
Which one?
That if your lordships want me to address your lordship on the obiter aspect.
And that which judgment, which proposition you will rely on obiter aspect?
First is this is not an obiter. Number two, assuming it is an obiter, binding.
No, you place that this is not an obiter.
Very well. Because I am very skeptical because on the last, I must point it out to the court, because in the last order, your lordship was pleased to, Millard, record that I will be only permitted to address on this judgment.
No, but to address on this, that point comes.
Very well. Very well.
That point comes. Obiter of Supreme Court is binding, for that nothing is required. But
yes,
as you have argued that when parties have deliberated
yes,
on the issue and the court has come with its finding with reasons,
yes, ma'am,
it's no more obiter, even if it was not the issue.
Oh, you don't have those, no?
You're ready with the judgment today?
That judgment, but I don't have.
Sorry? আমাকে যে ঘরেই দেয় acoustic problem থাকে.
Right. No, because of that
because
fan.
of the
Because of fan.
Yes.
But yes, this is.
No, that's all right.
But that judgment, but I don't have right now handy with me. But I shouldn't pay for time also for that. I leave it to the court. I shouldn't.
No, I want that. I want that. That even if obiter of Supreme Court binding not required, but when the parties have deliberated on a issue which was not issue before the court has dealt with it with its own reasons and came to a finding, it's not an obiter. That I require.
Really?
Come on some other day, because I tell you why,
Well,
Mr. Sarkar also.
Well, one more thing before your lordship, Millard.
No. I am expressing my difficulty. Because I'm really, I am running with a very heavy determination. To me, at least, I find it to be very heavy. And therefore, I have to justice to that determination preliminary and primarily. So,
but this is part of that determination.
No.
The matter being assigned to your lordship, Millard.
That is always, but so no problem. Come on some other day. On that judgment, you will make you just place the judgment. Then Mr. Sarkar will submit.
But I have to pray for another leave. There is even a subsequent judgment. The judgment which I placed is on 8th of October. There is a judgment on 13th of October. There is a judgment of the Supreme Court on 13th of October.
Much later than this.
Provided your lordship permits. I am not seeking leave. I am just intimating the court that there is a subsequent judgment. But going by the last day's order, Millard, I cannot pray. I can only leave it to the court. Yes.
To give that judgment to Mr. Mitra also.
Very well.
In the month of October, you said 6th, 7th October.
Yes, this is I think 8th October. The other one is 13th of October.
13th? Is that auspicious?
For me, it's very auspicious. For me,
longer the matter remains pending, more judgments will come.
Sir, please take the mic.
The longer the matter will remain pending, more judgments will come.
The judgment should be shown in the Supreme Court for what it's worth. Supreme Court has delivered the judgment. Show to Supreme Court and say the learned trial judge is wrongly decided against me because of this judgment. Not to show here to reopen the case. No question.
But
of reopening.
yesterday, but your lordship must have read in today's newspaper. Yesterday, Justice Pardiwala made caustic remark on Madhya Pradesh High Court by saying that we are laying down the law and the high courts are not following it. And I told you it is reflected in the order of his lordship, their lordships, but it's not.
Very well.
Website.
Do one thing.
Hmm.
Agree for a date. Agree for a date. Subject to, of course, my list. You first.
But any
agree.
day next week, will it?
Next week.
Next week.
Not in the next week. Little time. This time I will have to take some more time because I have to.
One case he was cited.
No, very well, Mr. Mitra. I have accommodated both the sides.
I know. You're
Whenever both the sides wanted. But this time I have to primarily do justice to my own determination first.
I'm not assigned matters.
I will, but I have to do that also. So agree for a date.
Balancing act is required.
ডেট সাজেস্ট করো একটা সাজেস্ট করো
বলুন আপনি বলুন
না না তুমি বলো তুমি তো বলছো অসুবিধা আছে
না আমার অসুবিধা নেই
বলছি
বলছি অসুবিধা না জজ সাহেব তো নেক্সট উইক চাইছেন
but lordship can take it on any day now it need not be Tuesday and Thursday then.
No.
Yes,
I will take up Tuesday or Thursday. Thursday I will not be able to because I have
No, I'm saying
food hearing is there.
No, lordship
Yes, all
any
right.
day, original side can be
No, but
no need
you
not be
know,
Tuesday and Thursday. That's what I'm
Mr. Sarkar, the list, if you see, you will find
today we
so
are
many matters are made returnable.
No, that is all right, man. I'm just saying
With the interim order being expiring on that day, and the list is has to be arranged like that. So 9th December.
Very well.
Marked at 2 p.m.
10th, Lord. Can you make it 10th?
Take it 10th.
At 2 p.m.
At 2 p.m. Lord. 10th.
10th আমার কি অবস্থা না কি নি বুধবার আমি এখন very well come at 2 p.m. let's see he will complete with that judgment.
Yes.
Give the citation to Mr. Sarkar and give me a copy.
Give us a copy also.
Yes, will.
একটা কপি দিয়ে দাও
হ্যাঁ দিয়ে দিচ্ছি হাতে কাছে আছে অনেক আছে
নিয়ে নাও তুমি পড়ো আমি তো পড়ছি না give another copy Siddharth.
এটা এর মধ্যে রাখো
want to read.
আচ্ছা আমি একটা নেব না আমার হয়েছে আচ্ছা
হ্যাঁ
আসো
could I take the lordship's leave?
Mr. The last order dated. Come on, show me. Last order to go. The last order dated October 28, 2025 speaks for itself. Post up. Today, Mr. Kishore, paragraph. Today, Mr. Kishore Datta, learned Advocate General for the state, appearing for the award debtor stroke.
State is not here. WBIDC.
It is not here.
Learned Advocate General for the state, appearing for the award debtor stroke applicant.
Very well.
Under section 30, in section 36 within bracket 3 application under the Arbitration Act. Concluded his submissions on the basis of the judgment of on the basis of the latest judgment of the Honorable Supreme Court dated October 7, 2025 in the matter of একদম দেখে লিখে নাও আর ঠিক আমার মতো লিখবে বাবা in the matter of করে bold italics লিখে নাও এইটা ভার্সেস লাইফস্টাইল ভার্সেস অ্যামাজন যেভাবে আছে লেখা রিপোর্টেড অ্যাক্ট
অনেক কাজ করি এটা ছাড়া
Tatas are expected to be accepted. Such a big
We can go off.
Paragraph. Thereafter, learned Advocate General submits that even on a later date, on October 13, 2025, the Honorable Supreme Court has delivered another judgment, which, according to him, is pertinent on the issue. Being the latest law laid down by the Honorable Supreme Court. Being the latest law laid down by the Honorable Supreme Court in the matter of State of West Bengal versus Shanti reported at Ato. So sorry. Full stop. He prays for a further opportunity to make his submissions on the said later decision of the Honorable Supreme Court. Full stop. Paragraph. Mr. Sudipto Sarkar, learned senior advocate, appearing for the award holder, shall commence his submissions on the said two judgments on the next day, immediately after Mr. Dotto concludes. Full stop. Paragraph. By consent of the parties, the matter shall appear. Heading ache. Application bracket is specially assigned, marked at 2 p.m. on December 10, 2025. Yes, Mr. Mitra?
My lord, is it your lordship's pleasure to, my lord, my lord's pleasure to record that obiter part, or I don't address your lordship on the obiter part?
No, you have to. Very well. On the next day, Mr. Dotto shall also show the law on the proposition that when parties have submitted extensively on a particular issue, which is not an issue for adjudication before the court, and when the court comes up with its finding with reasons on the same, the same does not constitute an obiter. Same is not an obiter.
And even if it is an obiter,
the decision is not an obiter. But in any event, an obiter of the Honorable Supreme Court is always binding on the High Courts.
The submission, lordship's finding, lordship's recording. The last sentence is my learned friend submission or a lordship's observation.
No, I'll address on this point.
No, the obiter is always binding.
Shall also show the law on the proposition.
No. Lordship has said, my lord, that obiter, my lord, is also binding. Is that a submission, lordship recording or after?
He said that.
Then I'm all right.
Yes.
I have to argue that point.
He said
that. Is binding or not.
He said that. তারপরে করে দাও by consent of the parties বলে স্যাররা যেরকম বলেছেন ওনাদের। Yes, sir. Thank you.
I'm grateful.
হ্যাঁ, এটা ঢুকিয়ে দাও এখানে। Call the list.
I beg to appear on behalf of the plaintiff, petitioner before.
Before my learned friend starts, my lord, I have a humble prayer. My lord, I'm being led in this matter by Mr. Shobhoshaji Chaudhary. My lord, he's unwell for the last 2 days. He's not coming to court. My lord, will kindly keep it next week. He's unwell. He's on personal grounds. My lord, I'm seeking this time.
So
Adjournment.
fast over for the day.
My lord, if it could be next week, because I don't think he'll be able to rejoin court. He's presently unwell. That's my only prayer, my lord. If it could be kept not this week, my lord, it'll come up next week.
লিখো লিখো কি হয়েছে এটা এটা আমায় পাঠিয়ে দেবে
The health reasons I won't oppose, but this was accommodation
on
was
the
also
Mr. Your name?
Gaura Purokayastha.
Gaura Purokayastha, learned advocate, appears for the plaintiff. Paragraph, Mr.
Shaunak Mukhopadhyay.
On the prayer of Mr. Shaunak Mukhopadhyay, learned advocate, appearing for the
defendant.
Only one. Sole defendant.
Sole defendant.
Appearing for the defendant submits. On the prayer of Mr. Shaunak such and such, learned counsel appearing for the defendant, the matter shall appear under the heading adjourn motion on December 17, 2025. As the learned senior counsel leading him is unwell and has not been attending the court.
The pleadings are complete in this matter.
Next.
Your Lordship, I'm praying for not today. Mr. Praneeth Bagh, learned advocate for the plaintiff is.
You are for the plaintiff?
Yes, sir.
The defendant is also not here. Passed over for the day.
Item number 18.
Passed over.
Item number 19.
চলো হুড়ুর করে ডাকো
Lord, in this matter, I am appearing for defendant number 2, my lord.
Passed over. এই শোনো প্রদ্যুৎ চেক লিস্টে থাকবে যদি কালকে কিছু চেক লিস্টে থাকে একজন মোশন সেটাই দেবেন আমি যা থাকছে এরকম থাকবে
First over 21 to 22 তাহলে
নেক্সট না ওগুলো সব থাকবে আমি এইখানে যেগুলো পাস ওভার করি এই চেম্বার অ্যাপ্লিকেশন ফর ফাইনাল ডিসপোজাল আর মোশন চলো ডাকো ডাকো হুড়ুর করে ডেকে দাও
I
apologize. Next.
Your Lordship, I am appearing on behalf of the plaintiff. Today is fixed for filing reply by the defendants, but till today we haven't received any copy of the reply.
Opposition.
Reply to the affidavit in opposition to the GA number 5.
What is that application?
They have filed GA 5
for paying for
under order for a summary judgment in exercise of power under order 13A.
That has been filed by plaintiff.
That has been filed by the defendants.
Summary judgment by defendant.
Yes, Lordship.
Likhi, give your brief GA. কি বলে রে বাবা any provision in the Hey, Mr. Shorojit, right, whatever, Dashgupta, and you please come. Under the Commercial Court Act, is there any provision to pass a summary judgment for dismissal of suit? I have never heard of.
But summary judgment can the application.
Judgment is always there. That has to be filed by this, sought for by the plaintiff.
No, in this case, both the plaintiff as well as the
Yes,
defendant.
yes, but plaintiff can pray for dismissal of the suit by way of summary judgment.
Plaintiff, the defendant.
Defendant.
That is provided. In the provision. If your lordship sees some commercial.
Order 13A.
Yes, order 13A.
Order 13A of this
No. Commercial court side.
of
All
the
right.
CPC.
CPC. Yes, okay.
Court section amendment.
Yeah, this is an application praying for a summary judgment for dismissal of the suit filed by the defendant number. Madam?
Your Lordship, defendant number.
Defendant number 2.
Defendant number 3 and 2.
Claim and counter claim.
Defendant number 2.
But order 13A, not 3, rule 3. Grounds for summary judgment issue, lordship sees court.
Defendant number 2 and 3. 1 second, I will hear you. Yes. 1 second. Defendant number 2 and 3. Full stop. Affidavit in opposition has been filed by the plaintiff, but affidavit in reply has not yet been filed.
I appear for the defendant.
Paragraph. Therefore,
The defendant.
Mr. On the prayer of Mr.
Pourush Bandyopadhyay.
Pourush Bandyopadhyay, learned advocate, appearing for the defendants, applicants, time to file affidavit in reply stands extended till December 18, 2025. Full stop. The matter shall appear under the heading adjourned motion in the monthly list of January 2026.
Your Lordship, may Your Lordship kindly fix the matter on 17th or 19th of December.
But we'll.
एक मिनट शायद देखे नहीं है
But order 13A, rule 3. That's according to me, or it's the provision which provides the power to the defendant to apply for dismissal.
Rule 3.
Rule 3.
A.
Rule 3A.
Power of court to record admission.
No. Order 13A, rule 3.
Oh, acha, order 13A. Yes.
It starts with the court may give a summary judgment against a plaintiff or a defendant.
That, in my respectful submission, is a power given to the defendant to apply for dismissal, summary dismissal.
Okay.
That is the ground of my application.
ঠিক আছে আর এমএস কি নাম ওর নাম প্লেন্টিফে দিয়ে দাও এমএস দিয়ে দিচ্ছ চলো নেক্সট
Obligement.
চলো ডাক্তার
I am appearing on behalf of the defendant number 2 bank. It is that letter of credit matter, Your Lordship. Letter of credit matter, where I am appearing for the defendant number 2 bank. Mr. Rupak Ghosh is appearing for the
injunction is
on me, Your Lordship.
25. Your Lordship.
দেখে দাও হুড়ুড় করে দেখে দাও
Your Lordship, I'm appearing. Your Lordship, 25 and 26 I'm appearing. In 25 I'm appearing on behalf of the petitioners, Your Lordship. In 26 I'm appearing on behalf of the respondent.
25 is their application, 26 is mine.
Yes, Your Lordship.
And there is another application which is item 52 on the written statement, my lord, not being accepted within the first 120 days in the application. My name is Mr. HON'BLE Ghosh.
No, I'm there, my lord. I'm sorry I couldn't reach.
Led by Mr. Ishan on his legs, Your Lordship. If I could kindly get a short passover.
Led by
Mr. Ishan Jha. He's on his legs, Your Lordship. Very short passover.
passed over.
Cholo, Dr. So item 26, 27. Item 27, Your Lordship, against an order passed by this Honorable Court, an appeal has been preferred. And Your Lordship, just the Honorable Division.
Appeal is pending.
The appeal is pending, and the Honorable Division Bench was hearing the matter. But for 2 weeks, Your Lordship, the Division Bench is not there. Any date, Your Lordship, after 2 weeks?
Mr. Subhashish Sengupta. Hey, কত 27.
27.
27. Mr. Subhashish Sengupta, learned advocate appearing for the defendant.
Defendant number 124.
Defendant number 1224 submits that an appeal is pending before the Honorable Division Bench, and hence the hearing of this petition can be deferred for some time. Paragraph none appears for the plaintiff. Paragraph accordingly, the matter shall appear under the heading adjourn motion in the monthly list of January 2025-6.
I'm grateful.
Next. Chalo, document.
Your Lordship, I'm for the plaintiff in this matter, Your Lordship, plaintiff and the petitioner, Your Lordship. On 23rd December 2024, GA4, which was the respondent's application for extension of time to file written statement, it was already heard and disposed of. But the order did not record that GA4 was disposed of, Your Lordship.
I am appearing for defendant number 2.
I am for the
yes,
defendant.
Lordship. My learned friend is saying very correct. It was not disposed of, but 120 days we have filed it, our written statement at a cost of 5,000, and we have deposited the cost.
All right. So what is the other applications? Anything pending?
Yes, Your Lordship, 29, 30 and 31, which is our application.
And GA3 is our application.
GA3 is their application.
8. Section 8
application for?
arbitration. Section 8 arbitration.
Which one is section 8 of the arbitration?
GA3. 31, item 31.
Item number 31, Your Lordship.
Number 1, Your Lordship.
The main matter is
pending section 8, you have filed written statement.
They haven't objected. They haven't opted for filing a WS for the GA3. They have argued it, but it was again released by the Honorable Court, that matter. Earlier, the matter was reserved by the Honorable Court, but the Honorable Court, after due process of hearing on a very next date, released the matter.
The moment you have filed your written statement, how your section 8 will be heard?
Lordship, we have filed section 8 along with WS.
Along with WS?
Yes.
So WS has been filed in the department?
It has been filed. It has been on a record also.
So why section 8 will be taken up now? How will it be maintainable?
Lordship, the thing was, our time was lapsing of the WS. We have filed section 8 also on time. That section 8 was heard of by the Lordship, Justice Krishna Rao, sir. Thereafter, Lordship, after hearing to the matter, passed an order dictating on a open court that it is dismissed. Later on, after 10 days, the matter came again before the adjournment motion. And
no, section 8 was dismissed.
No, it was dismissed, but Lordship said that I haven't signed it. I need to hear back to the defendant as well as plaintiff. Plaintiff, I need to hear upon that. So later upon that matter was released. It is yet to be pending. It is yet pending. GA3. That is to be heard again.
Matter has been released. তাহলে তো assign করা তো হবে। তার আগে তো হবে না দেখি।
The matter was not released from this bench, Your Lordship.
It is coming before a regular rooster, I suppose, Lordship. I just tell the date. It was heard in the month of November. On 20th December is the order sheet where the Lordship said at that time the correction of the order dictated in open court.
23rd.
20th, 20 December. This court found that the several points raised by the defendant in the application have not been properly explained either by the plaintiff or the defendant. And thus the court is of the view that the further hearing should be given to the parties for proper adjudication of the matter. And thus the order which has been dictated by this court has not been signed. Let the matter come fixed on this. Counsel for Defendant 1 has filed the document showing that the amount deposited by Defendant 2 kept in separate account. Let the same be kept with record.
So it was kept as part heard.
It was kept as a part heard. Later upon, Lordship GA3 was released because it has come before a regular roster before the Lordship itself. So
when released? When released?
Lordship in the order, I don't think in the order there is not any specific order for a release.
কি বলে বলো তো
Your Lordship, the matter was not.
বলছি রিলিজ
It was not released, Your Lordship. It was coming in your regular list, Your Lordship.
I cannot take up because it is marked as part heard.
So Lordship, it may be kept
Also,
on. The main matter is coming on 30th January. It can come before 30th January.
IAGA Com 3 of 2024. This is an application for
Section 8 application, their application, Your Lordship.
GA3 is the section 8.
Defendant number 2. My application.
This is an application filed by defendant number 2 under section 8 of the Arbitration and Conciliation Act.
Yes, Lord.
1996. Full stop. The order dated paragraph. The order dated December 20, 2024, passed by a coordinate bench, shows that the matter was marked as part heard. Matter was fixed and marked as part heard. Paragraph. In view of the above, the matter stands released from the list of this court. Full stop. Paragraph. The parties shall be at liberty to take necessary steps in accordance with law.
Your Lordship, kindly note that GA4 was already been heard and
Disposed
of, Your Lordship.
Parties further submit that
It is
IAGA 4, IAGA Com 4 of
2024, Your Lordship.
2024 has already been disposed of by the coordinate bench. Chalo, next.
Lordship, and GA1 and GA2 shall come upon 30th of January. The regular matter is coming.
এটা কতটায় করলাম?
Your Lordship, item number 29 and 30 are our petition. One is injunction and another is judgment upon admission, Your Lordship. That is GA1 and GA2 respectively. It is coming in your regular list. Kindly post this matter on 30.
সামলাবো বলো তো করে লিস্ট সামলাবো। চলো
Lordship,
500 বার দেখা যাবে পরে দেখা।
Lordship, it may be kept on 30th January. I am from Rajasthan, Jaipur. That's why
All right, ওই দুটো নাম্বার দাও, দুটো নাম্বারই অর্ডার করো। জিএ কত বললাম সিরিয়াল নাম্বার?
1 and 2, Your Lordship.
29, 30.
একটা করে জিএ 1 কত?
29.
আর জিএ
2
30 দুটোকে একটাই অর্ডার করো, হেন্সফোর্থ একসঙ্গে অ্যাপিয়ার করবে। দেখো
on 30th.
The matters are already fixed on January. Are already fixed on January 30, 2026, comma, as submitted by the parties. Poster. Henceforth, both the said applications shall appear together under the heading motion adjourned. By adjourned motion, কি বলেছো?
Adjourned motion.
Adjourned motion. As a single serial number in the list. Paragraph. The the applications shall appear under the heading adjourn motion on January 30, 2024. 26. Next.
Item number 32. Item 32, Your Lordship, I am for the defendant. Identical issue which Your Lordship we argued, Your Lordship, today morning. Order 29.
Service of summons.
Yes, Your Lordship. We should wait, Your Lordship, till that particular judgment comes.
Yes.
There is
May
one
reserve.
decision, my lord. I don't know whether it has been cited before your lordship, my lord. Frost International, Justice Arijit Banerjee single bench decision, which says that if it is served, my lord, on a corporation, anybody having it with a receipt or with a stamp and seal of or the stamp of the corporation, that itself is good service. No requirement of service on any director. I think that because this is the issue here.
Frost International Justice Arijit Banerjee's single bench, but that too was, Your Lordship, I think Order 9 Rule 13 after decree, and Your Lordship, that staff received with a seal and signature. So that was, Your Lordship, the interpretation that the staff, if he is holding or she is holding, Your Lordship, the stamp, is the authorized representative of the principal. On that point, Your Lordship, let that judgment come, Your Lordship. Then
Because in terms of, my lord, today there's a sheriff's report. The sheriff has said it has been served. They're a company. Now both by hand as well as by registered post. Now Order 20, my lord, 29, Rule 2 has two alternative modes, either on the director or in the at the registered office of a corporation. So moment is satisfaction has been done.
Right. I will deliver my judgment, then I will hear it out.
Yes, sir.
Very well. Necessary.
Yes, Your Lordship. Lordship, may I just file the
May I
affidavit
file
and reply?
And what has already filed?
Whenever, Your Lordship.
Opposition was already filed.
On the identical issue. Since on the Mr. Shatodip Bhattacharya, learned advocate, appears for the
plaintiff.
Mr. Sengupta, learned counsel, appears for defendant. Full name?
Sengupta. Sengupta.
Subhashish Sengupta, learned, so sorry. Counsel appears for the defendant. Paragraph. This is an application filed by the defendant praying for extension of time to file written statement beyond 30 days, but within
beyond 120 days.
20 days.
No, is it commercial suit beyond 120 days on the ground?
Extension of time for
this
filing
matter,
written statements.
For recalling of the order directing undefended.
Huh?
This is
not in the
actually
nature.
application for recalling of the order by which the suit has been directed to proceed as an undefended suit.
In this matter, Your Lordship, there is no written statement. Our contention, Your Lordship, it was never served. And Your Lordship, on the basis of a short cause title, we filed because the matter came.
The issue involved in this application is whether in the facts of this case, time to file written statement can be extended in a commercial suit. Paragraph. Learned counsel appearing, Mr. Subhashish Sengupta appearing for the defendant, submits that today morning he has argued a matter for the defendant, where on the identical issue, the hearing has been concluded by this court, and the hearing has been concluded before this court, and the judgment has been reserved. Paragraph. In view of the above, this application shall appear.
It's one application.
The application shall appear under the heading motion adjourned. It's on affidavits.
On affidavit.
Motion adjourned in the monthly list of January 2026.
Only one prayer may I make, my lord. Here, since I did not have the opportunity in the morning to listen to Mr. Sengupta's argument, I would have relied upon Frost International. I don't know whether that was cited before your lordship. May my lord just keep it, my lord's record just one paragraph of Frost, because it's the same case that they will be arguing here, that the person who has received did not have the authority. So, my lord, this judgment, my lord, may kindly take into consideration, since it has fallen from your lordship that the issue involved with
But
this.
that judgment, Your Lordship, may not be applicable in that case. In that case, your lordship, no one was there who has accepted it, or we have admitted, your lordship, that the principal officer, your lordship, has accepted. Here, the things is different. Here, your lordship, the bailiff has gone and your lordship delivered it to one of the employee or staff who is not an employee of mine. That is our case here.
No, but their
Principal officer has received it.
there the summon has been received.
Yes.
Here also, summons have,
it will not.
Here also summons have been received in our case. Now the bailiff has given a report that yes, it has been received both by hand as well as by registered.
But not by
the registered
but not by
office.
the
Not
principal
required,
officer.
because on there we will see something else. Chalo, the higher.
So may I file, your lordship, the affidavit and reply, your lordship?
By extending the time to file affidavit in reply, comma, affidavit in reply filed by the defendant in this defendant is taken on record.
In the suit, my lord,
Copy has been served.
the evidence in chief is concluded, though undefended, but they have a right of cross-examination. My witness has been, but examination chief is concluded in
But
the suit.
wait for the time.
Yes, but the suit also may appear in January month list, my lord.
Sorry. Application. Very well, you give that judgment.
Yes.
Copy of the judgment you give it.
Yes.
Paragraph 15 and
question of law যেটা সিএবি করলাম ওখানে দিয়ে দিও।
Paragraph 16, my lord.
দাও আমায় দাও একবার দাও কিছু লিখতে হবে না ওর সঙ্গে দিয়ে দিও।
$16 and $17 possibly. 16, 15, 16. Codes free.
I'm grateful.
Grateful, Honor. Deeply grateful.
Appear for the defendant.
I appear for the plaintiff, my lord. My GA1, my lordship was hearing on the last occasion. But this is the circular issue of the Reserve Bank of India. Admittedly, my lord, I am an
একটা নোটও ছিল বোধহয় নোটের ফাইল ছিল না yes
yes. The
yes,
but there is a variance in respect of their affidavit. But there is some variance in their affidavit in opposition case. At the very initial stage of the affidavit in the pleadings, it has been indicated in their affidavit in opposition that they were never aware that I am an MSME unit, and since they were not aware, they could not have given effect to the circular. But my lord, documents have been disclosed which shows that my lord, they have recognized or classified my account as an SMA2.
কি কাগজ পাওয়া যায় না লাস্ট অর্ডার কেউ আনে না
Copy I have for handy.
সেফ কাস্টাডিতে থাকে যেদিন মামলা আছে সেদিন আসবে না
Safe custody. Safe custody আছে
Oh, because there was a perjury application that we had filed. Yes.
পার্জারিতে ওটা ছিল it is GA1.
No, GA1 is my application for interim relief.
So that is we are hearing.
Yes.
That is GA4.
That is no,
the
the perjury application is GA4, but the false statement was made in the affidavit in opposition in GA1. So I think one of the records of GA1 are now before the registrar. GA4 has been disposed of.
No, GA3
No,
has been
GA3 has been disposed of. 4 is my perjury. B was my learned friend's application for time to file the written statement.
Written, we have deposited the cost, Lordship.
First of all, for the day, কালকে অর্ডার জন্য রেকর্ড জন্য কোর্টে থাকে।
Very grateful.
Next.
This my application. This is Millard. A tender was floated Millard for welding of flash but welding of Millard the railway tracks.
Yes.
Now Millard, in totality, the contract was for 7,615 wells to be done by the plaintiff. Now, Millard, the issue Millard really pertains Millard the blocking period given by the or Millard the blocking period.
Exchange.
Yes. Blocking period.
Enjoying an interim order.
Yes, Millard. This Millard I mentioned in the morning. Millard, the issue here is Millard whether the blocking period when there will be no plying or Millard the railway tracks will be totally empty for the plaintiff to complete the welding process. Millard, initially there was a technology of Millard to use fish plates in the railway tracks. Now Millard that has now gone Millard and it has been Millard substituted by Millard the flash welding process. Now Millard, the welds are to be made by the plaintiff. The tender was for the welds.
Procuring welds.
Making the welds only to make the joints welds.
Achha. So you will go and provide that service.
Yes, I will go and make the welding.
Not welder.
I'm a welder. Now, Millard, initially there was Millard 7,615 welds to be made by my client. Now, Millard, the issue which revolves here, Millard, is the blocking period of Millard the trains not to be plied at that point of time. Now, Millard, there has been a constant Millard letters exchange between the parties, Millard by the plaintiff and Millard by the defendant number 1, that Millard we require Millard at least a blocking period Millard in excess of 5.5 hours.
In a day.
In a day. To complete it within the time frame.
That is not within the contract.
No, the GCC states Millard in accordance with the wish of the railways or Millard accordance with the Millard railways discretion of the railways.
Now parties
now,
have
Millard,
agreed.
Parties have agreed Millard
for 5.5 hours.
No, Millard, we have been writing to them and Millard they have been providing us Millard maximum of a period of 1 hour or 1.5.
Railways. And you are asking for
5.5 because Millard the time frame is the essence. Millard, time is the essence of the contract. Millard, keeping in view Millard the time being the essence of the contract, Millard 5.5 hours minimum is required
per day.
To complete the well 7,650.
So time is the essence of the contract for the total
contract. If Millard I want to complete 7,615 within the stipulated period as agreed by the parties, then I require at least 5.5 hours a day. Now Millard, admittedly Millard, not more than one, maximum for a period of 1.5 hours were provided.
Arbitration clause is there.
Arbitration clause is there, but it comes within the accepted matters.
My preliminary 2 objection is there. All agreement and other formalities was Agra Malar. Was that Agra? Agra, under Malar, Allahabad High Court jurisdiction. Number 1 point. Number 2, arbitration clause is properly there. So there.
Arbitration clause, you cannot take the plea unless you come out with a section 8.
That is true, Malar. But as far as the jurisdiction is concerned, Malar, that is true, Malar. And Malar, they are completing their tendership through mail, Malar. You also know that anybody can floating their tender in the world, Malar, any time, any site, Malar.
That's right. Now, if the tender process and concluded contract has arrived at within the jurisdiction of this court, part of cause of action is there. Where is the
that
difficulty?
is not, that is absolutely not. my lord.
Plainta আছে?
Yes, my lord.
Yes. Well, the plaint have annexed.
Page.
My lord, will find the plaint at page 433.
Plaint.
Plaint.
Page. देखिए.
433.
Only their point is that my lord, bank guarantee only.
My lord,
Otherwise
volume
not.
3.
ভলিউম 3 টা বের করতে আছে, আমাদের সার্ভিস করেন, আমাদের সার্ভিস করেন, সবগুলো সার্ভিস করেন। All the respondent, my lord, belongs to, my lord, outside jurisdiction.
পরের ভলিউমটা দাও। ভলিউম 4।
দিয়ে দিয়েছে।
উইদাউট অ্যানেক্সার আছে না, আমাকে আলাদা করে
Miller, the plaint I have annexed is without annexure because Miller, there will be repetition of the annexure again otherwise. So Miller, I have the plaint with me. I can hand over Miller the copy. I have not annexed, otherwise there would have been a repetition of annexures.
Where have you pleaded the clause 12 pleading? Paragraph 114. 473.
Yes.
What part of cause of action you have pleaded within?
Miller, first Miller, I have pleaded that Miller, the bank guarantee has been issued by Axis Bank, that is at Miller Park Street. Now Miller, the number 2 Miller, the tender was digitally signed within the registered office of the plaintiff. And
Digitally signed?
Within the registered, at the registered office of the plaintiff and submitted from the, he admitted that by email.
That
So
is
it
all
was from the, sir, we can't speak together.
Then?
It was from the registered office of the plaintiff. Now Miller, they are LOA. I have received at my office, within registered office, Miller, within this jurisdiction.
What is
Now,
LOA?
letter of acceptance. Accepted by me.
All right.
Now Miller, 48 hours, very.
Proceed.
Now Miller, the first issue Miller, I'll address that. Now Miller, kindly comes to Miller, I'll address the arbitration Miller issue first.
Arbitration, unless section 8 application is there, why will you address?
Now Miller, the issue was Miller 5.5 hours.
Have they come up with section 8?
They have not filed the written statement. No section 8.
That's all.
Nothing. Now Miller, the issue pertains to Miller, the welding. Now Miller, in Miller, there has been, Miller kindly takes Miller page.
What is the nature of injunction you are enjoying?
Miller, the bank guarantee has Miller directed not to be invoked.
Performance guarantee.
Performance guarantee. Because why? Because Miller, there has been Miller
was
bank.
It an ex parte order?
It was an ex parte order. Miller, now Miller, they have been appearing since December. Now Miller, the bank guarantee was Miller in effect. Miller, if any damage they would have claimed. The bank guarantee says Miller damages. They were to claim a damages from me. Then Miller, they can invoke.
Show me the clause in the bank guarantee invocation.
Now Miller, kindly see the bank guarantee.
341. Volume 3.
আচ্ছা 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 341 আছে বাবা 341
343 onward. Kindly see paragraph 1. Paragraph 1. In consideration, Miller, I am not reading Miller those addresses and Miller, kindly see carrying on business such and such opposite to such and such. Now, Miller, after the bracket, rupees 39 lakhs. Third line from bottom of paragraph 1.
Yes.
Against any loss or damage caused to or suffered or would be caused to or suffered by government by reason of any breach. Till date, even in their opposition, they have not raised any issue that they have suffered any loss or Miller there is any breach. On the contrary, Miller, it's
show me the execution of bank guarantee clause. Under which clause you were bound to execute the bank guarantee? Under the contract.
Miller, kindly see page 344. Para 9C. If a written claim or demand is served, nothing has been done so.
Time is still there.
Yes. Yes.
Time is still there. What makes you to rush to this court? Show me. Is there any threat for injunction?
Yes.
Show me.
Let my contract was terminated. Page 418. This volume. And Miller
contract
terminated on 19/9/2024. And Miller
page
418.
18. Volume?
Same volume, Miller, volume 3. And Miller the
wait.
last line.
Wait. Show me clause 62. Standard condition.
Yes, that was Miller. Miller, kindly take
page
140.
Wait.
It's 137.
Page
137.
What is that?
Clause 62. Clause 62.
6.62. Page
37. Volume 1.
One 37. $62. 138.
Starts from 137 bottom.
Which clause attracts the notice?
That's kindly takes 138. Penultimate paragraph.
Read.
Then and in any of the said clause, the engineer on behalf of the railway may serve the contractor with a notice in writing to that effect, and if the contractor does not within 7 days after the delivery to him of such notice proceed to make good its default insofar as the same is capable of being good and carry on the work or comply with such directions as aforesaid, the entire satisfaction of the engineer, the railway shall be entitled after giving 48 hours notice in writing the hand of the engineer to rescind the contract as whole or in part as specified in such notice, and after 48 hours notice the final termination notice should be issued.
Yes, then
this was the termination notice. This after this receiving this we have come to this court challenging this. Now the issue
after receiving page 418.
418. Prior to the clinching issue here is that the bank guarantee is of 39 lakhs. My amount of 66 lakhs are still lying with them, and that is my contract claim. And in much in excess of 39 lakhs they are protected, because in the reply to the termination, if kindly takes
what is the fraud or special equity you have pleaded? Show me.
Special equity I have pleaded that that the railway tracks.
Show me.
Kindly take the plaint, page 433.
Show me from your injunction application.
Para 87, page 33.
Yes.
First clause A, I have just pointed out to your lordship that much in excess of the amount of bank guarantee is is my claim. The naam prayer the second ground is they have terminated my contract. They have not raised any breach or damages suffered from me. On the contrary, that railway tracks are being my wells which are being done by me are being used and utilized in usual course of business by the railways on a minute-to-minute basis.
Have they raised any objection during performance?
On the contrary.
During performance?
No. On the
suddenly one notice of termination.
Suddenly 48 hours.
19 September is the sole notice.
No.
Previously,
there are 40
there are some notice.
40 hours.
No, you I'll hear.
Yes.
No, previous to 19 September.
Yes. There are 148 hours notice at page 414.
Dated
17/9/2024.
Page
414, and on 16th August 2024 there is a 7 days notice.
Page
16th August is at page 368 and 17th September is at page 414.
Both on volume 3.
Both on volume 3. And to each and every notice, I have my reply.
What is the case in the opposition?
The preliminary objection is there twofold. Is that this does not fall within the jurisdiction of this honorable court, and there is an arbitration clause. Those are two major objections. Now their third objection is that they have issued notice of 7 days and 48 hours. To my reply is that those have been the blocking period is the main issue. I have been writing to them time to time that 1.5 hour blocking period is not possible.
Mr. Dasgupta, that blocking period, no blocking period, those are matter of trial. Those are matter of trial. All right, these are your submissions.
Preliminary, may I show I'll just what my lord had pointed out and fallen from your lordship. Not only there was no objection or demur. On the contrary, the engineers have signed the logbooks. Both the all the log.
Any job satisfaction certificate issued?
Yes. Kindly sees
satisfaction certificate.
Yes, page 410.
What is that?
Certificate of satisfaction. May I just for a moment check 410, volume 3. Volume 3 টা কোথায় গেল আবার? হ্যাঁ,
dated.
হ্যাঁ, 27th August 2024.
Page
410. So after issuing 7 days notice, they have issued certificate of satisfaction. 7 days notice was 16th August. This is of 27th August.
All right.
410.
Let me see.
Yes.
V3.
Yes. No, it's V3. V3. Kindly see clause 1. Digitally signed, so my lord will not find physical signatures. Atul Kumar Jori. Kindly see clause 1.
How have they dealt with this document in opposition?
This is annexure AA1.
AA1.
Gives him one. Gives him. A1. Yes, paragraph 52. Opposition that I have pleaded in paragraph 52.
Whatever, how have it been dealt with?
Yes, no comments. Kindly takes page 20, para 35 of their opposition. Para 35, page 20 of opposition.
And yours is petition page?
Para 52. Para 52, page 19.
19. And theirs is para 35?
Para 35, page 20. No comments.
Your 52.
Not only that.
Wait. What is this 140 wells?
Yes, my lord. 140 wells were being completed till that date.
So you have, as of now, you have completed 140.
No, I have completed, my lord, in excess of 700 wells as
You
of
have
now.
completed. Any subsequent objection raised? They have issued a satisfaction up
Apart
to,
from no, apart from, my lord,
they have issued a satisfaction certificate up to 140. You have done 700. In between, any objection raised?
no, 7 except, my lord, 7 days notice has been, my lord, gone because after that 27th August document has come. My lord, there in the meantime there is only 140 days notice. There's 2 days prior to termination.
That's right. 27th August is there.
So 7 days notice goes.
7 days is 16th
16th
August.
August. Yes.
And then 17th September.
Yes.
Those two are the
Those
only.
two are the, yes.
Only.
Only.
Acha, show me, take me to your paragraph 52.
Yes. My lord,
I have seen 52.
For a second.
35 of the opposition.
Yes, my lord.
Yes, I have seen.
Yes, my lord, for a second, my lord. My lord, in paragraph 35, they are dealing with 51, 52, 53. Kindly goes through that one. In paragraph 35, they are dealing with 3 paragraphs of 51, 52, 53. Kindly see 51 and 53 also.
Yes, show me.
The petitioner states that the balance wells which are duly completed by using the second machine have also been jointly inspected. So it's, my lord, even after 140 wells, subsequent to 140, balance, and have been jointly inspected by the representatives of the petitioner and the respondent number 1, and the same has been duly signed by the representative of both the parties and entered in the logbook maintained by the parties. My 52 my lord has seen. Now my lord says 53. As such, the respondent number 1 is stopped from either contending that there was any deficiency or defects in the wells completed by the petitioner either with the first machine or with the second machine, or from using his superior and dominant bargaining power to compel the petition to carry out the wells afresh or to take any penal action for not complying. Now, all these paragraphs he has dealt with as no comments. So, no denial. And there has been no denial to the certificate also.
These are your submissions?
That may I show the the logbooks, if Millard wants to see the logbook, signed and countersigned by the parties for the other 700 rest.
Page
379 to 390. 79 to 390.
Logbooks.
Logbooks.
140 to 700. Or all 700?
All 700. Now, Millard, apart from this, as Millard.
Yes.
Millard had taken note of 379 to 390. Millard, apart from this, Millard, till date.
Millard, how have they dealt with? Which annexure, which paragraph? Show me your pleading in the petition. How have they dealt with?
Logbook, page, para 51.
Para 51.
51, letter Z.
All right.
They have said no comments.
Yes, yes.
Now, Millard also kindly takes paragraph 41 once.
Yes.
At page 15.
40?
15 of the application.
Paragraph?
Paragraph 41. Page 15.
Yes.
Now, the petitioner states that the said wells were duly inspected by senior engineer, and only after the inspections were completed were the summary of the said well duly encapsulated in the logbook, duly signed by both the representatives of the petitioner and the respondent number 1. The report of the inspection as mentioned in the logbook would make it clear that at no point of time did the respondent number 1 ever find any clause or reason to reject the wells. no fault or deviation from the appropriate quality or specifications was ever found in such 314 wells duly completed by the petitioner.
Letter V.
Letter V.
Page
double letter V. 379.
79.
79.
Page 79.
379.
379. 379. How have they denied?
Kindly take page 15, para 29 of the opposition. I say that page 15, para 29.
Yes.
I say that executed 314 wells were not inspected by the senior engineer. Now, text page 379. Contrary to the records.
Para 29, I say that
only one line positive statement, if that be so, that 314 wells were not inspected.
Now page.
Kindly take 379 in annexure V.
Page 379. Which volume?
Logbook.
Which volume?
The third volume. So sorry, it's a voluminous. Signed by the railway.
P79, volume 3.
Yes, annexure V.
Yes.
Kindly see. The railway signature and the contractor signature all are being signed. So the statement made is contrary to records.
That's all.
That to this my one more contention is that till date, time has passed long back. There has been no written statement filed.
Why are you coming to written statement?
No,
we are on an interlocutory application. If they have not filed within 120 mandated days, matter ends.
Only one issue, I wanted to show. Though order date rule 5 provision, deemed the no denial means admission.
Next.
The very well.
You tell me one thing. Have I appeared for this Rahi?
Rahi files is a seasoned contractor.
Have I appeared for Rahi?
Not in this matter.
Have I appeared for Rahi?
Yes, once my lord had appeared.
Then I will not take up.
But my interim order expressed to them. My lord will have to extend the interim order. My interim order then goes.
No. You go and mention before the court.
No, where do I mention at 4 o'clock, I have been mentioning since morning. My lord, extend the interim order, then release. I have no difficulty. But this is a 2025 suit. My lord had appeared in 2014.
Same company. That is the problem.
এই আপনি জানতেন এখন বলছেন ওটা সেম কোম্পানি
জেনে বলছি
তাহলে
কেন বলবো না আপনি আপনি কথা বলছেন
প্লিজ
বারবার
This is not the place for this.
প্লিজ
না উনি অনেকক্ষণ ধরে করছেন although he is my junior friend.
My lord, extends the because I lose my interim order. Where will I go at 4:10?
The moment if I cannot take it up, then
my lord can take it up.
No.
My lord, then my lord, my interim order goes. My lord, that is a 2014 suit.
No.
And that was my lord Rahi GPT. This is Rahi Infratech.
Whatever. Ashu.
But my lord, extends my interim order then, my lord. My lord, my right will be lost.
My preliminary objection also, my lord, jurisdiction point, my lord. Because, my lord, this is Agra.
Should have mentioned immediately. These things should be
This is a
told.
2025 suit.
Maybe, but
and that is Rahi GPT. This is Rahi Infratech.
No, it's all right. After hearing for
Well, my lord will extend my interim order. I am losing that, otherwise.
Mr. Dasgupta, if I extend the interim order,
then
why
I am
should
losing. My lord, I mentioned in the.
not take up the matter?
My lord, there is no difficulty in taking up the
That's
matter.
right, but I will not take up. Then it should have been immediately pointed out that your lordship has appeared for the group long back.
That is Rahi GPT. That company has gone done and dusted.
Very well, but I would have
my interim order.
I would have immediately.
In my thought, even I dreamed. I have not thought of that.
No, very well. I will make that clear.
Yes,
But you get it mentioned tomorrow.
My interim order is still today.
I will let me observe my things.
Or short for if the order, my lord, tomorrow is getting.
Yes, you make submissions to the court. Yes.
I have no difficulty. My lord may.
All right. Let me see what can be done.
My lord will kindly extend my
After
interim
about
order
hearing
and protect us for some time.
more than around an hour, it appears to this court that for the group companies, for some of the group companies of the plaintiff, I appeared in the matter whilst in the bar. Poster. Paragraph. Hence, this matter stands released from my list. Full stop. The records are placed forthwith. It ekkuni kore daw, ami ekkuni পাঠাচ্ছি. The records are placed. Records shall be placed forthwith. এই ekkuni নিয়ে জমা করো. Records shall be placed forthwith before the Secretariat to the Honorable the Chief Justice for taking steps for assignment. Paragraph. It is submitted that the interim order which is subsisting for long in the matter and last extended on
16 September expiring today.
দেখি কি আমি এক্সটেন্ড করেছি নাকি দেখি অর্ডারটা দাও last extended on October 27, 2025 is surviving till today. কি বললাম পড়ো
I can make it 16 September if I'm not wrong.
Listen, please hear to this order. Is surviving till today. Full stop. Since I have released the matter, I shall not extend it.
But when I lose my right.
And it is expected.
Interim order.
It is expected that.
Not a contest.
It is expected that.
May I? My lord is of the view that substantive right should not be taken away. My lord, good bad indifferent. My lord, I have obtained an interment which has not been vacated. But my lord, I lose it because of this.
No, you will not lose. Let me make my order. কি বললাম?
My lord, no court will extend my lord after this, my lord.
The ex parte interim order.
It would not be proper for me it would not be proper for me to extend the interim order. But
No, that's 410. Where do I go? 415.
it is expected that, but upon immediate, but the petitioner shall be at liberty to apply for an immediate extension, immediate assignment, and shall be at liberty to pray for
At least
the necessary
this
direction.
week. No, where do I go at 415?
Item number 13 also similar.
Go and mention now. I'm signing the order.
Item number 13
এক
also
নম্বর কোড
similar.
আসলে উঠে গেছে দেখ
Item number 13 similar man.
doubt
Which was
13
passed.
কি order হয়েছে?
that written statement one that morning.
Same party
My lord, already passed order in that. There is no difficulty.
Direction for
Nobody
report all this.
Very well.
Very well. Recall this.
It should have been mentioned. This should have been.
Then Milad, my every matter will be released. I will be matterless before your lordship.
No. If sir, I have appeared, what to do?
Milad, this is Milad. This is not that one. My lord.
Very well. I will not. তুমি এক্ষুনি করে দাও, আমি এক্ষুনি সই করে দিচ্ছি. Let them take steps.
এক নম্বর কোড.
Still time is there.
But I don't know whether lordship is sitting or not. That Milad.
Please go and take steps.
Milad,
not
well, I'm
enlarge.
going, but Milad, allow me to come back after. If the my lord has risen, Milad, then allow me to come back to your lordship, Milad.
I will not extend. But I make এক্ষুনি অর্ডারটা চেপে আনো না, তুমি যাও এখানে বসে চেপে দাও, আমায় দাও।
Item number 13 also kindly.
Mr. Counsel, I have released this matter. When I will take up item number 13 again, if I take it up, show me this order.
Just I mentioned this.
Show me that order.
Yes.
Don't try to take any advantage of this situation.
That is my intention.
No.
Only assist the court, man.
No. So when
not my intention,
sir, I don't take you as a miss.
And officer also there, man.
I am not taking you a miss. But the thing is, when I shall be again taking up 13, you show me this order and get that released.
Yes,
I'm saying that only.
Developed.
Saying that only.
Item number 35.
এক্ষুনি করে দাও, কোথায় আছে? শোনো, ভুল না করে নিয়ে এসো না আমার চেম্বারে। যাও তুমি চলে যাও, ভুল না করে নিয়ে এসো। কিছু থাকতে হবে না, আমি হাতে লিখবো। রিলিভার ফোন করে ডেকে নাও। রিলিভার থাকাটা ইম্পর্টেন্ট না, এটা করাটা ইম্পর্টেন্ট ভাই। প্লিজ গো অ্যান্ড ডু ইট।
His exuberance, Milord, any court will extend that interim order. Any court will extend that interim order.
Anytime. That's why I mentioned
if
all
this bank guarantee is invoked, the court will say put in. You can't take advantage of this situation.
Absolutely.
But anyway, Milord, I don't find my other side.
I'm appealing for the defendant number 2. Defendant number 1 is.
What is the matter?
Milord, this is a dispute which arises out of, Milord, one of those outlets of Subway. Subway. Now, Milord, there is a chain of defendant. Your lordship knows, Milord, that Subway is basically a company which has an international. Now, he has appointed franchisees. Franchisees have appointed me, and I am running this stall. Now, Milord, they have a Milord system of weekly coming and inspecting my store, giving me instructions.
You are a franchisee.
I am a franchisee.
What about the other defendants? Are they appearing?
Yes, Milord, they were appearing. It was contested. Initially, I took an ex parte interim order. Thereafter, upon contest, it was extended. Affidavits have been exchanged. The interim order is continuing and has been continuing. The interim order is in the nature, my lord. What had happened is, when I was carrying on this business on a regular basis, my lord, at one point of time, they said that we will buy you off your entire business. This is the agreement. This is the consideration. I agreed to that. That's all admitted position. Once I agreed to that, thereafter this agreement was not taken forward. It stopped at there, and thereafter, they started coercing me in such a manner that the business comes to an end. What happened is this, pending this agreement and pending, their decision as to how they will proceed. What they did is, there is a system that all the raw materials for making these sandwiches and burgers have to come from a designated person, which is the defendant number 2. Now, there is a policy that the defendant number 2 will give me these foods on credit. 2 weeks credit, and after I consume this, I pay him back. This system was going on. Now, to coerce me, what they did, initially they stopped this credit line. So they say that instead of getting this credit, you first pay off. Now, that was not, the original arrangement. This can only happen provided I am in a position, I am not running the shop in the manner they desire. So I thought, and that is one of my complaints, that since you are not willing to buy me off at the price which you had quoted, now you are trying to put me in such a situation that I give up to your demands. Thereafter, there are other outlets, which they abruptly said that they have units have closed. Therefore, D2 was directed not to serve any raw materials to me at all. At that stage, there are mails and emails. When I came running to your lordship, the court felt that it should not be terminated, otherwise they're in due process of law. Then the after that, we served them. They came. They offered a settlement. We also agreed to a settlement. Now, the problem is this, the dispute which I have raised is for specific performance of that agreement. Now, if they say today, the situation is this, if they say that we are ready to buy you off, then during the tenure during which this decision is pending, I am not supposed to do anything, because their offer itself says you don't have to upgrade the store anymore. Because I'm going to buy.
In view of this agreement, you have not upgraded your shop.
Because if I upgrade it, then the agreed consideration that gets changed, because some
status will change.
Status will change. Now they are now insisting that no, we will not buy you. You upgrade. Now I say that very well. If I upgrade, then don't arbitrarily terminate my contract, because this upgradation takes a huge cost. Huge cost. Now, the personnel who come are their person. If a glass is broken, they pass adverse remarks against me. If the cup is little dirty, they pass remarks. They say that the wall is not clean, and all these things have all started. This is basically a way of trying to coerce me to give up to their demands. So I'm entering an order of injunction. I need to take your lordship through a.
What is the nature of injunction?
The nature of injunction which I have is not to term.
আচ্ছা, ওর রিলিভার কেউ ফোন করোনি? করেছো তো? বাস তাহলে
your lordship has the order of 24th of December 2024. আছে order sheet আছে? The দিন না judge সাহেবকে।
24th of
December 2024.
Presentation ছিল এটাই।
The nature of injunction is at page 6 of that order.
Yes.
The defendants, their main agents and servants are restrained from giving any effect or further effect to the pre-termination notices dated 27 November, December in respect of stone numbers 5, 6, such and such, till 21st January to immediately serve copies. Then we served, then they appeared, which is mirrored on 21st of January 2025. They prayed for time for filing opposition. No appeal carried from this order, no vacating application made. So, Millard,
The appeal has to be before Supreme Court.
yes. It's a commercial dispute, yes. But Millard, this is ridiculous.
Another thing, what is troubling me, when there is no otherwise leave prayed for in a plaint, mediation failed, non-starter comes, the plaint has to be admitted before the master straightway.
Yes.
Subject to scrutiny.
Yes, that's the usual process.
No, but it's now being placed before the court. I've seen this practice is going on since long. Even today morning, I admitted one plaint subject, simple one sentence, referring to that page. This is the non-starter report. Plaint stands admitted, subject to scrutiny. So this has to be done by the master. I don't know, but it may so happen that commercial suit is now designated under a commercial act, so the commercial division has to take up.
Millard, I can show instance, Millard, where this practice which your lordship is speaking of was followed. Non-starter.
I initially sent two that there is no other leave required, so place it before the master.
It comes before your lordship only for the limited purpose of either seeing that 12A should be granted.
Either 12A or clause 12 or order to rule 2 or deficit court fee.
And all
but
this
if
is
none is there, none is there.
Scrutiny has to be done by the
Scrutiny fair enough, but why before the court?
No. That has to go before the department.
But it's all the time. It's fine. I'm finding it's coming to not me before the court since long.
Well, I told your lordship on the other day, my lord, courts, different courts have different practices. Your lordship being a, my lord, having your lordship's bar days in this court, my lord, your lordship is much more akin to the practice. But other courts, they have other practice. Like lordship's predecessor had to be satisfied by me on one day. Why is a probate contested? Then I found out that in generally probates are generally uncontested in other proceedings in other states, and from probably that place also from where his lordship was coming. So he was little taken by surprise that we contest
suits are filed.
That suits are filed, proceedings are contained. So probably that is what has happened.
But your interim order is still there.
It's still there.
You're for?
I'm for defendant number 1, your lordship.
Yes.
I'm led by Mr. Kundalya. He is engaged in another court.
That is neither here nor there. Not you are there. Yes. Proceed for time.
I can give the order sheet.
আচ্ছা জানেন তো প্রায় নতুন নাকি আজকের লোক নাকি দেখছিস 14 সালের
So what defense they have taken in opposition?
Your lordship, may I? So your lordship, our primary defense is that there's no concluded contract in this case, right? So what was sent was only a draft of the contract which they themselves have never signed. Therefore, our contention is that no suit lies in this case for specific performance because none of the parties have ever signed the contract itself.
Oral contract, specific performance does not lie.
Your lordship, in this case, there's no oral contract as well. There's specifically a draft given to them, right? They have never signed or sent it back to us. So then, in our submission, there is no valid contract subsisting. The only document which has been signed by both the parties is only a non-binding indicative letter which has been signed, and that itself also has a different jurisdiction clause, which only exclusive jurisdiction clause, which designates the courts in Delhi to have exclusive jurisdiction.
This is the shop where from the shop is running.
Shop is running from Calcutta itself.
কোথায় এগ্রি করেছে
Just by agreement, if no cause of action is there, you cannot confer jurisdiction.
Lordship, once my senior is here on another day, we can satisfy you on this point, Your Lordship. We have referred to various.
You get ready. You get yourself ready.
Obliged.
Senior will come. If the even if the senior is stuck elsewhere, you will argue. No problem.
Yes, Lordship.
You get ready.
Yes, Lordship.
Tell me when.
Lordship, anytime next week.
Yes, Mr. Dutt. Asho. Mr. Shuman Kumar Dutt. ও আজকে কাউকে দেখতে হবে না, এসো এসো এসো। দাও আমি হাতে লিখে দিচ্ছি। Mr. Suman Kumar Dutt, Learned Senior Advocate, has commenced his submissions appearing for the plaintiff. ওই তো দিদি এসে গেছে, ছেড়ে দাও। লিখুন, Mr. Suman Kumar Dutt, duty T, Learned Senior Advocate, has commenced his submissions on behalf of the plaintiff, stroke petitioner. We shall continue on the next day. Mr.
Onindo Kannan, Your Lordship.
Onindo
Kannan, K-A-N-A-N.
Kannan.
Kannan, K-A-N-A-N.
Onindo Kannan, Learned Advocate, led by Mr.
Vipul Kundalia, Your Lordship.
Vipul Kundalia, Learned Senior Advocate, appears for
Defendant number 1, Your Lordship.
defendant number 1.
My lord, Satik Raut.
Mr. Satik Rahut.
ROUT, my lord.
ROUT, Raut. Learned Counsel appears for
Defendant number 2. Defendant number 2, my lord.
Matter shall appear under the heading কিসে আছে এটা? Adjourn motion on. বলো কবে? Tell me.
My lord, item 36 also connected application. My application, that is.
For?
In this matter only.
For?
Defendant number 2.
No, his
application. That is an application for deletion of name.
Deletion of?
My name from the array of parties. Defendant number 2.
That has to be heard first. Full stop. বলে দিচ্ছি। কত আছে 30?
36. Next item.
The parties are all here, Mr. Dutt?
Yes.
36? Parties are all same. তাহলে 36 এ একসঙ্গে অর্ডার করুন। কি বললাম?
যে আমাদের জিএ কোড এটাও
দুটো মামলা একটাই অর্ডার হচ্ছে, হ্যাঁ? এবার ওটাও কাটুন, লিখুন। Defendant number 2 submits that IAGA Com
2 of 2025.
2 of 2025 is an application filed by the defendant number 2 praying for deletion of its name from the array of defendants. Full stop. Considering the above, comma, IAGA 2 of 2025 shall be heard first on the next day. Paragraph. Both these applications shall appear against a single item, against a single item, against a single serial number. কোনটা রিলিজ করলাম সেটা পার্ট হার্ট বলে, হ্যাঁ ও আরবার বলি both these কি বললাম shall appear one after another serially under the heading adjourn motion on agree between you.
I am here wherever I am.
1st December.
Auspicious.
I am not there on 27th.
First time na, 1st December to monthly list বেরোবে। December 3. Yes, Mr. Dutt? December 3, 2025. Fifth. না, ফিফথ হবে না, শুক্রবার হবে না। December 8. Yes, Mr. Dutt?
What knows where will I be on the 8th? How do I say? Keep it, Millard.
On December 8, 2025.
File and the signed copy can be sent to the
Yes. অর্ডারটা ডাকো।
সার্ভার করে তো আপনার খালি সাইন কপি চাইছে। সই করে
তুমি সাইন কপিটা দিয়ে দিচ্ছি, অর্ডারটা ফোন করো। শোনো, হাইকোর্টের অর্ডার হাতে লিখে সই করলেও হবে, আমার সইটাই ম্যাটার করে। দাও, এনেছো অর্ডার? ফাইলটা পাঠিয়ে দাও।